ಆದಿತ್ಯ ಒಂಚೂರು ತರ್ಸಿ. ನಾನೇನು ತಲೆ ಕೆಡಿಸ್ಕೊಡು. ತಪ್ಪಿದ್ದು ತಮ್ಮ ಯಾರು
ಹಲೋ ಕೋರ್ಟ್ ಆಫೀಸರ್. ಹಲೋ ಕೋರ್ಟ್ ಆಫೀಸರ್, ಇದು ಕಿಣಗಿ ಸಾಹೇಬ್ರ ಕೋರ್ಟ್ ಅಲ್ಲ ಇದು? ಹಲೋ ಹಲೋ.
ಹೇಳಿ ಸರ್. ಕೇಳಿಸ್ತಾ ಇಲ್ಲ, ಹೇಳಿ ಸರ್. ನಿಮಗ್ ಕೇಳಿಸ್ತಾ ಇಲ್ವಾ ನಾವು ಮಾತಾಡ್ತಾ ಇರೋದು?
ಇದು ಕಿಣಗಿ ಸಾಹೇಬ್ರ ಕೋರ್ಟ್. ಇವಾಗ ಕೇಳಿಸ್ತೈತೆ ಮೇಡಮ್. ಕಿಣಗಿ ಸಾಹೇಬ್ರ ಕೋರ್ಟ್ ಅಲ್ಲ?
ಹೌದು ಸರ್.
ಅದೇ ನಂದು ಫಸ್ಟ್ ಮ್ಯಾಟ್ರ್ ಇದೆ, ಅದು ಎಲೆಕ್ಷನ್ ಮ್ಯಾಟ್ರದು. ಅದಕ್ಕೆ ಕೇಳಿದೆ ನಾನು. ನಿಮ್ ಧಾರವಾಡ ಫಸ್ಟ್ ಮ್ಯಾಟ್ರ್. ಓಕೆ ಓಕೆ.
ಅದೇ ಮೇಡಮ್, ಸೀರಿಯಲ್ ನಂಬರ್ 26 ಹೇಳಿದಲ್ಲ ನಾನು.
ಫಸ್ಟ್ ಮ್ಯಾಟ್ರ್ ಬಿ ಚಿದಾನಂದ.
ಹೌದು ಮೇಡಮ್. ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ, ವೆದರ್ ಅದು ನಾವು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಹಾಕಿದ್ವಿ, ಎಂಟ್ರಿ ಮಾಡಿ ಇವ್ರು ಸಾಹೇಬ್ರದ್ದು ಆರ್ಡರ್ ಏನ್ ಮಾಡಿದ್ರು, ಮತ್ತು ಇದು ಡಿಸ್ಮಿಸ್ ಫಾರ್ ಏನೋ ನಾ ಇನ್ಫೆಕ್ಚಸ್ ಅಂತ ಏನೋ ಮಾಡಿದ್ರು. ಅದು ರೀಕಾಲಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ರೀಸ್ಟೋರ್ಡ್. ಅದು question is whether when petition is restored, interim order also restored or not. That is the question has to be clarified. That's all. ಅದು ಹೇಮಂತ್ ಚಂದ್ರಗೌಡ್ರ ಸಾಹೇಬ್ ಮುಂದೆ ಬಂದಿತ್ತು, ಅವ್ರು ಇವರಿಗೆ ಮತ್ತೆ ವಾಪಸ್.
ಓಕೆ ಸರ್. ಸೀರಿಯಲ್ ನಂಬರ್ 2 ಯಾರು ಸರ್? ಧಾರವಾಡ ಬೆಂಚ್ ಇಂದ ಮಹೇಶ್ ಒಡೆಯ.
ಎರಡು ನಂದೇ ಇದೆ.
ಆ ಎರಡನೇದ್ರಲ್ಲಿ ನೀವೇ
ಎರಡು ನಂದೇ ಅವ್ರು
ಹಾಕೊಂಡಿದ್ದೀರಾ?
ಅಲ್ಲ, ಮೊದಲಲ್ಲಿ ಕೂಡ ವಕಾಲತ್
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 2 ಧಾರವಾಡ
ಕೊಟ್ಟಿದ್ದಾರೆ.
ವಿಡ್ರಾಯಲ್ ಆಗಿರೋದನ್ನ ರಿಕಾಲಿಂಗ್ ಕೇಳಿದೀರಾ?
ಮೇಡಮ್ ನಾನಿದ್ದೀನಿ, ಅವ್ರದ್ದಲ್ಲ.
ವಿಡ್ರಾಯಲ್ ಕೇಳಿಲ್ಲ.
ಹೇಳಿ ಮಹೇಶ್
ಮೇಡಮ್, ಅವ್ರದ್ದಲ್ಲ, ಅದು ನಂದು.
ಗೊತ್ತಾಯ್ತು, ಹೇಳಿ.
ನಂದು
ಅದೇ ನಂದು ಸೆಕೆಂಡ್ ಮ್ಯಾಟ್ರ್ ನಂದು ಮೇಡಮ್, ಚಿದಾನಂದ್ ಅವ್ರದ್ದಲ್ಲ.
ರಿಕಾಲಿಂಗ್ ಹಾಕೊಂಡಿದೀರಾ ವಿಡ್ರಾಯಲ್ ಆಗಿರೋದ್ನ?
ಹೌದು, ಅದು ರಿಕಾಲಿಂಗ್
ಏನಾದ್ರು ಸೈಟೇಷನ್ ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ?
ಅದು ಕಳ್ಸಿಕೊಡ್ಬೇಕಾ ಅಲ್ಲಿಗೆ?
ಹೌದಲ್ವಾ? ವಿಡ್ರಾಯಲ್ ಆಗಿರೋದ್ನ ರಿಕಾಲ್ ಮಾಡ್ಬೋದು ಅಂತ ಯಾವ್ದಾದ್ರು ಸೈಟೇಷನ್ ಇದ್ರೆ ಕಳ್ಸ್ಕೊಡಿ ಸರ್.
ಅಲ್ಲ, ಕರೆಕ್ಟ್, ಅದು ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಡಿದ್ವಿ.
ಹೌದು, ಅದಕ್ಕೆ ಸೈಟೇಷನ್ ಕಳ್ಸಿ ಸರ್. ನೀವು RJ ಚೇಂಬರ್ ಗೆ ಮೇಲ್ ಮಾಡಿ ಇಮಿಡಿಯೇಟ್ ಆಗಿ.
ಮೇಡಮ್,
ಪ್ಲಾಸ್ಟಿಕ್ ಅಲ್ಲ
ಮೇಡಮ್.
ಯಶ್ವಿನಿ ಬರಲ್ಲ, ಅವರು ಡೈರೆಕ್ಟ್ ಹೋದ್ರು ಅನ್ಸುತ್ತೆ.
ಮೇಡಮ್, ಮೇಡಮ್,
ಬೇಕು. ಮೂರಕ್ಕೂ ಬಂತ, ಒಂದೇ ಬಂತ. ಮ್ಯಾಮ್, ಅದು ಟೂಲ್ ಕಿಟ್ ಬೇಕು ಮ್ಯಾಮ್, ಇಲ್ಲದ್ರೆ ಆಗಲ್ಲ ಅದು. ಶಾಲಪ್ಪ ನಡೀತಾ ಇದೆ.
Read the memo if you can.
Lord, may I have one submission, my lord?
Might ಬರುತ್ತೆ ಕನೆಕ್ಟೆಡ್ ಆದ್ರೆ ನೆಕ್ಸ್ಟ್ ಇದರಲ್ಲಿ ಇದು ಮಾಡಬಹುದು. ಬರುತ್ತೆ ತಗೊಳ್ಳಿ ಬರುತ್ತೆ.
Lord, I have one submission, my lord.
ಬರುತ್ತೆ ನೆಕ್ಸ್ಟ್
Lord,
yes sir.
the serial number, actually, my lord, serial number 26, it was in the regular list, my lord. It was listed before his lordship, Suraj on 16th, and it was advised to list on 18th, and both the councils to be present to furnish some of the documents. But on 18th, inadvertently, it was not listed, my lord. So we submitted before the court, and it was ordered that today it has to be listed before his lordship, my lord. But unfortunately, by oversight, a posting memo has been filed from my office, and it is being posted for posting memo. Lord. Serial number 26. Lord.
Serial number 26.
What do you want?
Now, my lord, it has to be either it has to be heard, or date may be fixed on 24th, my lord. Or
Yes, make a submission when a case is called.
Lord, apart for petitioner in this matter, madam.
Yes, make a submission when a case is called.
Dharwad matter, sir. Matter pertaining to Dharwad bench. Serial number 1.
My lord, I appear for the petitioner. I appear for the petitioners, my lord. My lord, your lordship kindly peruse the order sheet, my lord. What happens is, my lord, on 19/12/2018, there was an interim order that respondent shall not proceed with the matters by issuing calendar of events. But subsequently, my lord, your lordship on 11/1/2021, your lordship has passed an order, writ petition dismissed for having become infectious. Subsequently, thereafter, my lord, on 19/2/21, IA 1 of 21 was filed by for recalling the order on 11/1/2021. My lord, your lordship recalled on 23/2/2021. The order dated. The order dated 11
before this bench.
Daisy.
My lord, kindly look into it was listed before the lordship Hemant Chandangowda. My lord, your lordship has not clarified whether when the petition is restored.
What do you want?
Interim order granted earlier is a clarification. Yes, my lord.
No question of clarification, sir. Once a
Whether when the petition has
once if a petition is restored, any interim order granted, it will be restored.
yes, that is the clarification required. That
We have filed
that-
application under IA number 3 of 21, my lord. So I have to comply with the office of.
that is the clarification I required, my lord. That's all. I have produced so many judgments also, my lord.
I request you.
Lordship, that's why
So
it
let it
was
be
posted
posted
before
before the
lordship
roster
to
bench
clarify
is
that text.
This
My lord, unless my lord, there is an order of the his lordship Justice Hemant Chandangowda, my lord, your lordship, we request you kindly peruse the lordship order, my lord, the lordship Justice Hemant Chandangowda has passed an order. You go before the same judge and let him clarify, the honorable judge. That
Recorded
has been posted.
2/4/2021.
Yes, my lord.
Huh.
Yes, ma'am. I thereafter, my lord, a calendar, before calendar of events, there was an interim order on that day, my lord.
This
I
report
approved it, sir.
21 on the submission made by the learned counsel for the petitioner disposed of the petition as having become infectious. Thereafter, the petitioner filed an application I-1 of 2020 for recalling the order dated 11 January 2021. So this court on 23/2/2021 recall the order dated 11 January 2021. Court order dated 21/4/2021 that we listed before this bench. So this court has not heard the matter in court. Question of considering the taking of this matter before this bench does not arise. Raised is directed to place the matter before the roster bench for obtaining the necessary permission from the Honorable Chief Justice.
But the only request is made, Lordship, whether interim order continues or not. That is the only when petition is restored. That is the question of the required. That is the clarification required. That's why the learned judge has posted before Lordship.
Yes, Maheshwarya.
I appear
Only
for
thing is,
the,
my lord,
I appear for the appellant, my
restored
lord.
or not,
I
that
made
is
this,
clarified.
I made this application for recalling the order, my lord. My lord, on the trust of the, my lord, the respondents have promised, my lord, the matter is settled. But my lord, instead of settling the matter, my lord, again, my lord, they have filed a FDP, my lord, instead of acting on the, my lord, the compromise. They have filed the FDP, my lord. Therefore, my lord, the appellant, my lord, constrained to file this application for recalling the, my lord, the. My lord, I wanted to serve the complaint, they refused to take, and they said that the file has been taken by their party.
We got a notice on the council appearing for respondent in the FDP.
Permitted to serve the copy. Even I brought to the notice of the trial court advocate also. Instead of they refused to take. Therefore, I will may I take the emergent notice on the IS if Lordship permits.
FDP number?
FDP number, I furnished them, that's they have filed the FDP.
Appellant, learned counsel for the appellant submit that the respondent taking undue advantage of the dismissal of appeal filed the FDP proceeding. He submit that the parties have entered into a compromise. In spite of it, the respondents are not complying with the terms and conditions of a compromise petition and filed the execution proceeding. And the appellant has filed an application for recalling the order dated 28 January 2020 to stop in view of the urgency made out by the learned counsel for the appellant. Appellant is permitted to serve a copy of applications filed with the appellant on the council appearing for respondent in FDP number.
I forgot to bring the it is there. Permit to FDP proceedings are served the copy.
Serve a copy and then thereafter you move the matter.
Date may be fixed, I request your Lordship.
Move the memo. This is
Because
matter.
they are pressing the hurriedly in the FDP proceedings. They are knowing that.
For that reason, you are directed to serve a copy on the council appearing for respondent in the FDP proceedings.
Much of it.
Number one, such notice, serial number one,
Malad, I am appearing for the petitioner in this case, Malad. In this case, Malad, the defendant number 2, Malad, before the trial court, had filed the application, Malad, before the court, requesting the court to permit him to lead further chief examination, and also
for the petitioner, issued notice to respondent. In addition to it, petitioner is permitted to serve a copy of the petition along with the annexures on the council appearing for respondent. There shall be a stay of further proceedings in invoice number 192 of 2015, pending in the file of civil JMFC, Peripatna, till next date of hearing.
2 and 3 may be dispensed with notice to the 2 and 3 because they are my counterpart with the court.
Seeks permission to dispense and notice to respond number 2 and 3. Submission is record notice to respond number 2 and 3 is dispensed with at the risk of the petitioner.
Please, madam.
Move Shri Ketan Kumar.
I have deposited the amount as per the order passed in this the earlier writ petition. Yes. Yes, you are with the man.
Unfortunately, he has not filed anything.
That's all.
3 months time.
When WP came to be disposed of? 21987. Huh? When? What was the order? To deposit you 25%. I will deposit it. Correct. You have not showed your bona fideness in depositing the amount. For payment, you will become a handicap. Issue notice corresponding. Issue notice corresponding. If you want to order, I'll dismiss it just because you have not complied the order passed by this court in the earlier petition. You have not deposited the amount. So you don't have any respect to the court orders. If you want, I'll dismiss it, no issue. Just I'm issuing a notice. At least you should get some breathing time for depositing the amount.
Serial number 3, Shri B. Ravindra Prasad.
Or the learned counsel for the petitioner. In addition to it, petitioner is permitted to serve a copy on the counsel appearing for respondent before the trial court. Learned counsel for the petitioner submit that the petitioner filed an application for amendment of plaint or written statement. Plain that before the commencement of trial. Before the commencement of trial, the trial court has rejected the application solely on the ground that application filed with the petitioner is belated. Hence, in view of the submission made by the counsel for the petitioner, there shall be a stay of further proceedings invoice number 8741 of 2017, pending on the file of 17th additional city civil session judge, Bangalore, till next date of hearing.
Serial number 4, Shri N. Tejish.
For the learned counsel for the petitioner, issue notice to respondent. In addition to it, this petitioner is permitted to serve a copy of the petition along with the annexure on the learned counsel appearing for respondent before the trial court. Learned counsel for the petitioner submit that prior to the filing of this suit, earlier respondent has filed a suit for partition in separate possession, which came to be abated. Further, he submit that without seeking for setting aside abatement, has filed a fresh suit. He further submit that the suit filed by the respondent is not maintainable. The trial court, without considering the said aspect, has rejected the application filed under Order 7 Rule 11 CPC. Hence, in view of the submission, there shall be a stay of further proceedings invoice number 6 of 2021, pending on the file of Senior Civil Judge JMFC, Pandavpura till next date of hearing. Not below the is accepted.
I appear for the appellant's notes. With the leave of your lordship's notes, I want to place few more documents notes on the file. I will serve the copy to the other side today. Notes, now itself I will serve them. Lordship, may I request this not to be taken tomorrow notes, because I don't want them to take it surprise. The documents may be relevant because I have pleaded in the appeal, but by oversight I have not produced it. I will place those documents and I shall argue it, my lords.
At the request of learned counsel for the appellant, let the appeal be listed in the second week of March.
Looks, I appeal for the appellant in this matter, my lords. Appeal is by the ESA Corporation against the order of ESA Court.
Take out a notice.
Please, my lords. Much obliged.
I appear for the appellant's counsel, my lord.
Yes.
Is a case, my lord, where in respect of a trust came to be created in the year 1982 by one person, by Rishi Prabhakar.
Yes.
And the trust deed provided that the trustee shall be for life. And the co-opted trustees, Lord, will not have power to appoint additional trustees. Kindly see, Lord, page 42. Clause 4. Trustees can also co-opt. Page 42.
Yes.
Trustees can also co-opt other members as additional trustees or for ad hoc purposes. There, subclause 9. The appointment of trustees mentioned is above for life. However, it is open to the trustees to resign their offices if they so desire. The vacancies caused in the office of the trustee shall be filled by the remaining trustees or by appointment of suitable person. All vacancies thus might arise from time to time in the office of the trustee shall be caused to be filled by appointing suitable person by remaining trustee for time being. The co-opted trustees or ad hoc trustees, however, shall have no power in the matter of filling up the vacancies. So it so happened that all the trustees died. Kindly see page 53. The only 2 trustees remained. The 2 trustees said they went to the court under 92, saying that we are only co-opted trustees. We have no power to appoint trustees. So kindly look into the matter under section 92. They made an application. In this supplementary trust, they say there is one clause, Lord. Kindly see page 63. Page 63, clause 8.
Yes.
The appointment of trustees is for lifetime, unless the founder Rishi Prabhakar or his successor decides to change any of the trustees. However, it is open to the trustees to resign this office, so and so. This Rishi Prabhakar did not appoint any successor. Now, it so happened once this Rishi Prabhakar died in 2014, his wife and son says, no, we are the successor to Rishi Prabhakar, and they went straight away on their own, executed a third supplementary. They are not trustees at all, page 79. They executed a third supplementary trust deed, saying that now we are the legal representatives of this Rishi Prabhakar. So therefore, after he dies, we will become the successor. Successor is to the office of the trust, not to as a legal representative. They create this third trust, Lord. Kindly see page 79. Is the deceased Rishi Prabhakar's wife and son create this third trust. And they say, no, we will represent the trust, Lord, is their case. In fact, the third trust itself says that I am the successor, I have the legal heirship certificate, so therefore I am entitled to. They were never trustees. Now there are only 2 trustees remain. Now a person who is not a trustee executes another trust deed. They say, no, we are the real trustees. They are trying to withdraw funds from the bank. So that is why, my lord, we filed this suit for injunction. Page 79, my lord. The court holds they are successors. So therefore, they are entitled to. Kindly see, my lord, the order passed by the court. There is only.
Come to para 11, page number 20.
Yes, para 11. Even otherwise, since the materials placed on record by defendant at this stage show that alleged plaintiff trustee secretary, namely Satnarayana K, is no longer a trustee, has been discharged from his position on 19/11/2000. This is wrong because this is on the basis of this third trust, where they say, no, we have discharged everybody.
Take out a notice, take out a notice.
They are drawing money from the bank
Can I just interfere, my lord? I'm the counsel appearing for the respondents in the trial court. I'll accept notice for all, my lord. In fact, we were about to file a caveat today when we found out this case was
Let
listed.
them accept notice, but let them not draw money, my lord. Let both sides not draw money from the bank. Otherwise, my lord, this entire thing will become infructuous. They want to draw money which is there in the bank accounts of this trust.
My lord, I'll file my objections within a week. This matter may be heard within a week.
It's all right. One day they will
Meanwhile,
withdraw.
don't precipitate the matter.
We're not precipitating the matter, my lord. The bank account is
Lord,
closed.
let them not
So
draw
good then.
money, my lord. I will also not draw money. Let them also not draw money from the bank. Let it remain till the issue is decided. I am asked for other relief, but as an urgent measure.
Correspondence 1 to 6, huh?
All the respondents, my lord, 1 to 6. I'm the counsel appearing in the trial court.
Placed on record. Learned counsel, senior counsel, Ashok Karnataka submit that the respondents taking undue advantage of the impugned order are trying to withdraw the amount from the bank. Submission is placed on record. Learned counsel to the respondent submit that the respondent will not precipitate the matter till next date of hearing. Even learned senior counsel appearing for the appellant also submit that the appellant will also not precipitate the matter. Submission is made on placed on record. Let the appeal be listed in the second week of January.
Other matter also, my lord, is connected with.
Same.
My lord,
It can be connected, my lord, both matters.
yes, the full set with the annexures may be handed over, my lord, at the earliest.
7-8 connecting.
I have already submitted our revised compromise to them on the very day, my lord.
My lord,
They are not replying.
we have not received a response, my lord. My
What is
clients
it?
have been trying to reach.
What is this going on? If you are not interested in a
No,
compromise,
my lord.
tell me
No,
this
no,
was
my
the
lord. No, my lord.
where is the
The very day
procedure
I go
for
to
filing a
Joyappa
draft
through
before the
email.
court?
My lord, the clients have already.
If you are not interested, you tell me.
No, my lord, no, my lord. I'll
I've
check up
already
with the
written,
clients, my lord, a week.
modified and send
My
it
lord,
to by
a
email
week's time
itself.
may be granted, my lord. I'll check up with the
Yes,
clients.
you argue the matter, will dispose it of.
My lord, a
You
week's
argue
time
the
may be
matter.
granted. I'll check with the.
No question of granting. Matters of 2014.
Yes, my lord.
Yes.
May I please, my lord?
No question of adjournment, sir.
My lord,
What is this?
time.
Filing a draft compromise petition before the court, whether the court should approve the draft compromise petition.
No, my lord. No, my lord. A week's time.
Who
I'll
filed this draft
confirm with the
compromise
clients.
petition? Who filed the draft compromise petition?
I also filed what is the modified petition also.
What is the necessary, sir? You must file a fair this one final compromise petition.
They are not giving the final compromise petition. They are giving a lot of conditions.
Yes, you argue the matter, will dispose it of.
So these are, my lord. These are suit for partition filed by the minor.
Yes.
After returning majority.
My lord, a date may be fixed, my lord, for
No,
argument.
sorry, madam.
Also will appear,
Sorry. If you want to
only
argue,
it may be
otherwise.
passed over. My lord, it may be passed over.
No question of adjournment.
It may be passed over, my lord.
Yes, you argue.
This is the position, my lord. In a suit for partition,
Yes.
I sought an injunction order not to interfere with my property involved in the suit.
Yes.
A scheduled property and B scheduled property is the property is involved. I am entitled to 1/3 share along with the other member dependent 1 and 2. The third dependent is a cornerstone. They are the joint development agreement entered into, for which I am not a party to it. So the court granted partial order stating that 23% share to be deposited, to be kept in case for the retention. That is not the purpose. So now the 1 acre land has to be given to me. 1 acre must be separated from the other parties. And then the new joint development agreement to enter into. I am entitled for 1/3 share in the property. Because 1 acre, that is not in dispute. So therefore, my submission before the court is the order of the trial court is wrong, and the order has to be said that the entire injunction order to be granted in dispute property unless my 1 acre land is demarcated in the property.
My lord, only one submission, my lord. Sorry for the interruption. Because I thought the matter was stated for the compromise because we have given a proposal.
Sir, please go through the order sheet. Please go through the order sheet. Please go through the order sheet.
Can I request for a passover, my lord? I will make, because I just opted out of another hearing to make a submission.
Correct. Where is the procedure for filing a draft compromise petition?
My lord, because I was not able to reach Mr. Sundaresh. That was the difficulty.
Mr. Joyappa came to me through email and I have written this with a modified compromise petition.
My difficulty was the physical logistics of getting it cleared by them, nothing else.
Pass, sir.
Oblige, my lord.
Learned counsel for the appellant submit that the value of the appeal is more than 15 lakh and please to place the matter before the division bench. Submission is placed on record. Registry is directed to place the matter before the division bench. To be listed before the division bench. File a second set.
Your Lordship, grant 1 week time, Your Lordship, I'll ask because Your Lordship, with the fresh matter. So the office has raised the objection with regard to maintainability. So Your Lordship, I will go through it and I'll grant 1 week time.
Appellant seeks time. Call up to 2 weeks.
Obliged.
My Lord, I appear for the appellant, my Lord. The value of the suit, my Lord, is less than 10 lakhs. My Lord, I may be given liberty to approach, my Lord, the district court. Certified copy may be directed to be returned, my Lord.
Learned counsel appearing to video conferencing submit that appellant may be permitted to withdraw the appeal with the liberty to present it before the proper court. Submission is placed on record. Appeal is disposed of with aforesaid liberty. Registry is directed to return the certified copy of the impugned order after retaining photocopy of the same.
My Lord, time spent, my Lord, may be excluded. My Lord.
Pardon?
Time spent in the appeal may be excluded for the purposes of limitation, my Lord.
Section 14 says what it says.
Lord, yes,
You
my Lord,
should
but
not ask this one.
yes, my Lord, very well.
That too from a civil office.
Yes.
Three grounds. Summons not served, affected from COVID-19. Some forcibly took the signature on the comply the office objection. You want a final order or you want to comply with the office? Yes, Margit. Yes. Neer kodi, water kodi. Suit for ejection. Forum? Please. Do you admit ownership of the respondent? One not 6 notice. 106 notice on the Transfer of Property Act. Sunil, better take it before next bench. If you want a disposal, I'll dispose of. Only on 3 grounds you have filed an application under Order 9 Rule 13. Saying that summons was not served in the court of examination, you have admitted that you have received a summons. Scope under Order 9 Rule 13 is very limited. Better you file an appeal. How much time do you want to tell? How much time do you want to vacate the premise? No, how much time? How much time do you want to tell me for vacating the premises?
There is some amount of consideration which is not being asked. We can admit it as policy. We need to use the question of this. I am not going to tell that before the court. What is the same thing? Not being asked for. I done it to verify. It is as per me approximately. Admit it. That can also be solved out. I think we can just do it.
Yes, Mr.
Not so.
That is so then you are not challenging the sale deed. You are not challenging the sale deed. Now, how can you take this ground?
Because of the financial constraints.
At the request of learned counsel for the appellant seeks time to comply with office objection. 1 week time granted to comply with office objection.
One last in the business, the entire thing will be rendered in circular.
You want a disposal will do. Only on 3 grounds you have filed an application under order 9 rule 13. You have seen the admission in the cross examination.
No, but you're sleeping.
No, you know that wherever there is a case, that is a case, then this court will grant an interim order.
Serial number 14, Sri Nagaya.
What about the process fee? Carry out, could you? The net counsel for the petitioner submit the petition. He has carried out amendment in the office to verify. Let the petition be listed in the 2nd week of March. She has filed a memo for retirement, wherein Q Narasimha Murthy filed a wakalat with NOC. Memo is in view of the memo is placed on record. Vyas Rao case is permitted to retire from the case for the petitioner. The registry is directed to print the name of GU Narasimha for petitioner. Let the petition be listed in the 2nd week of March. Interim order granted earlier is extended till next date of hearing.
Present, my lord, I appear for the writ petitioner.
Yes.
2 objections have been raised, my lord. One regarding awaiting service of notice to one of the respondents, and the second, my lord, is for respondents to file their wakalat.
Await service of notice to respond number 7.
Malad,
Yes, Pawan Kumar. Learned counsel.
Malad, one submission. Malad, in respect of respondent number 17, he has not represented before the trial court also, Malad.
Any notice is issued to him.
Yes.
Await service of notice to respond number 1 to 17. Learned counsel Pawan Kumar seeks time to file a wakalat for respond number 8 to 15. 1 week time granted to file a wakalat.
My lord, I pray for the interim order to be extended, my lord, until the next date of hearing.
Until wait till the matter is dictated.
Apologies, my lord.
Let the petition be listed in the 2nd week of March. Interim order granted earlier is extended till next date of hearing.
Grateful, my lord.
Appear for the petitioner, my lord.
I own apology, Lord, this mistake has happened because of my inadvertence. Lord, 3 days time or 4 days time in Lord, file the undertaking.
You are taking an adjournment repeatedly.
No, Lord, what happened was that there was a COVID, therefore I saw it last week, Monday when it was listed, I was before the award, therefore I could not appear for the court.
Otherwise, will grant an interim order.
But just 4 days.
Otherwise, will grant an interim order.
Just 4 days time, Lord, I'll file the undertaking.
Correct. Since from
10-1, my lord.
Up to that, my lord.
10-1, you are seeking an adjournment.
91, my lord, because there was a COVID situation.
Correct. Will pass an order of status quo to maintain as on today.
My lord, kindly grant me 4 days time, Lord. That is sufficient.
No. Shall I record
just 4 days time, my lord. I will file the undertaking within 4 days, my lord. Kindly grant me 4 days time. Just till Friday, my lord. I'll see that I will file the undertaking before this.
Yeshua Prasad.
My lord, the matter may be taken up on Thursday, my lord. If they don't submit the affidavit, my lord, then in that case, my lord, interim order stay may be granted as prayed for.
Learned counsel seeks time to file an undertaking as per the order dated 10-1-2022. If the respondent fails to file an undertaking on the next date or hearing, appropriate order will be passed. Let the petition be listed on Thursday.
Grateful.
Okay.
Await service of notice in respect of respond number 2, 3, and 7. Interim order granted earlier is extended till next date of hearing. The release the petition of receipt of service of notice on respond number 2, 3, and 7. File acknowledgement in the office. Await service of notice in respect of respond number 1, 2, and 4. Interim granted earlier is extended till next date of hearing.
When I appear for the respondent caveator.
Learned counsel for the petitioner 6 clears the court to withdraw the petition with the liberty to file appeal. 96 of PPC. Submission is placed on record. The petition is dismissed as withdrawn with the aforesaid liberty. Registry is directed to issue the return the certified copy of the impugned order after retaining photocopy. The impugned order is important. Registry is directed to return the original documents after retaining the photostat copy. Number 1 to 8. The petition receipt of service of notice and response to
accepted. And the time is granted to enable me to file a counter. If you want to get it, let it be confident. The respondent have the matter was the argument we are not amending up. Not happy with the matter. You can't and of course, respondent they have prepared already started the court. And of course, the
the trial court has heard the matter.
I am not heard. I am not been heard. Because the matter happened. The matter was
Sir, in the writ petition and the supervisory power, whether respondent has gotten a no. You see, virtually it amounts to bragging on the matter and then you being a senior advocate, Learned counsel for the petitioner submitted. Petitioner has complied with the office objection. Submission is placed on record office to verify. Entry earlier is extended till next date of hearing. Let the petition be listed in the second week of March.
Serial number 23, Shri K.R. Krishnamurthy.
Look, what is the copy of acknowledgement?
Hello. February 5.
For the petition the order dated 10/2/2023. I served a copy of writ petition along with the annexures and the council appearing for respondent before the trial court that was filed on 16/2023.
May I appear for the petitioner, my lord? The petitioner is working as a petitioner in the Gram Panchayat, my lord. On 13th Gram Swaraj Panchayat Act passed the resolution expunging all charges against the petitioner. That is where in respect of this, my lord. Subsequently, Panchayat also written a letter to the auditor to explain all those remarks. That resolution passed by the Gram Panchayat finally, and in the appeal prepared against that resolution by one of the Gram Panchayat member, the appeal came to be dismissed by the Chief Executive Officer Jilla Panchayat, my lord. However, the Executive Officer Jilla Panchayat, while acting as a quasi-judicial authority, made an observation, my lord, in the order Annexure F, stating that the appeal is dismissed. However, the issue will be considered as a complaint on administrative side. That to that extent, the impugned order is challenged before this honorable court, my lord. Subsequently, my lord, as per the instructions given by the very same Chief Executive Officer Jilla Panchayat, the very same Gram Panchayat has passed a resolution dismissing the petitioner from service, my lord. On pre-occasion, they have given the clear chit to the petitioner on the same issue. However, subsequently, the very same Gram Panchayat passed one more resolution without considering the previous resolution and without issuing any notice to the petitioner, my lord. In fact, the previous resolution passed by the Gram Panchayat was a detailed and considered decision taken by the Gram Panchayat after recording the statement of the staff members. I am aggrieved by the subsequent and recent latest decision taken by the Gram Panchayat with Annexure F, dismissing the petition from service, my lord.
Yes.
In the scope of Karnataka Gram Swaraj and Panchayat Raj Act, there is no scope for passing the second resolution, my lord, on the very same issue, my lord. In fact, in the previous occasion, my lord, specifically acting under the power vested with the Gram Panchayat under section 113, Gram Panchayat has passed the detailed resolution.
Yes. We accept notice to respondent 1, issue notice to respondent number 2 to 5. issue notice to respond number 2.
I prayed for stay of connection F, my lord.
But whether a dismissal order can be stayed,
My lord, is my lord.
whether a dismissal order can be stayed, order of
Panchayat developed
termination.
25, HS Prashant.
the
Yes, take out a notice.
Submission to the resort.
You got any objection?
Please.
Appellant filed IA-2 of 2020, seeking for condonation of delay of 233 days in filing appeal. In filing appeal, learned counsel for respondent submits no objection to allow IA-2 of 2020, accepting the reasons assigned in the enclosed application. IA-2 of 2021 is allowed. Delay of 233 days is condoned in filing appeal. Let the appeal be listed for admission.
Actually, it is in the regular list, my lord. Actually, on 16th, it was listed before the lordship Suraj Govindraj, and it was advised to present both the advocates physically to furnish some of the citations on 18th. 18th, inadvertently, it was not listed, my lord. And I submitted, and it was again asked today. But by inadvertently, we from my office filed a posting memo. Because of that, it has come for posting memo. Now, either it may be heard or date may be given for 24th, my lord.
For petitioner, my lord, date may be fixed, my lord. Date may be fixed.
Date 24th ಗೆ ಪರವಾಗಿಲ್ಲ ಸ್ವಾಮಿ 24th ಗೆ ಫಿಕ್ಸ್ ಮಾಡಿ ತಾವು.
Petitioner filed IA-1 of 2021 for posting the
petition. My lord, respondent
IA-1 of 2022. IA-1 of 2022 is allowed. Let the petition be listed in the first week of March.
No, my lord, date may be given 24th. ಅಲ್ಲ date ಕೊಡಿ ಸ್ವಾಮಿ. ರೆಗ್ಯುಲರ್ ಅಲ್ಲಿ ಉಂಟು ಸ್ವಾಮಿ ಅದು. ರೆಗ್ಯುಲರ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಉಂಟು.
Kindly extend the entry madam.
ಅಲ್ಲ ರೆಗ್ಯುಲರ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಉಂಟು ಸ್ವಾಮಿ 24th ಒಂದು ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿ ಸ್ವಾಮಿ 24th ಗೆ ರೆಗ್ಯುಲರ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಉಂಟು ಅದು.
So the notice was issued to the LRs of deceased respondent.
No, they made an application to bring the legal heirs of respondent number 5. I'm for the
LRs of deceased respondent number 5 on IA-1 and 2 of 2022. Pardon? Yes. When this order was passed? 27.1. Petition filed IA-1 of 2017 for correction of office order dated 19/1/2017. Post of this court, perused the application filed by the petitioner. This court wide order dated 19/1/2017 granted an ad-interim order. Granted an ad-interim order and and it is also granted an interim order, ad-interim order. It is also observed that the presence of the party as per the interim order may continue, but it shall not be able to resist the execution proceedings in accordance with law. Instead of typing as final decree proceedings, it has been wrongly typed as execution proceedings. In view of the same, application filed with the petitioner is allowed. I1 of 2017 is allowed. Order dated 19/1/2017 is modified. The party shall not be able to resist the FDP proceedings in accordance with law. Whether notice was issued to the issue notice to propose the LRs of this is respond number 11 on IA1 and 2 of 2020.
The issue of punishment has been staying at the stage of independence evidence.
Whether court can dispose of the application without bringing the petition without bringing the LRs of this is respond number 5. Whether court can dispose of the writ petition without bringing the LRs of this is respond number 11. Without issuing notice to the proposed LRs. It is not yet ordered.
My lord, in respect of serial number 28, my lord. My lord, in respect of serial number 28,
yes,
we have filed Wakala respondent number 11 LRs, my lord.
So and so submit that he has filed a wakalat for LRs of this. You already filed a wakalat for LRs of this is
Yes,
respond
my
number
lord.
11.
Yes, my lord. My senior JG Chandramohan, my lord.
Submitted filed a wakalat for LRs of this is respond number 1. Submission is placed on record. Office to verify. If wakalat is filed for proposed LRs of this is respond number 1. Registry is directed to print the name of some. Yes. Do you got any objection to allow I2?
My lord.
Do you got any objection?
I did not, my lord. We have filed the wakalat, my lord, for impleading us. No objections, my lord.
Petitioner filed IA2 of 2021 and 3 of IA2 of 2021 to bring the LRs of this is respond number 11 on record. Learned counsel appearing for the proposed LRs of this is respond number 1 submits no objection to allow IA2 of 2021, accepting the reasons assigned in IA2 of 2021. IA2 of 2021 is allowed. Petitioner is permitted to bring the LRs of this is respond number 11 on record. Petitioner to carry out amendment to furnish an amended cost title. Let the petition be listed in the second week of March. First to carry out. I filed IA1 and 2 of 2021. IA1 set aside and IA2 to carry out amendment. Copy for it. Second week of March. Will come in the second week.
29. Sri GT Kumar.
Why it is posted today? What about respond number 5, madam? Petitioner filed IA-1 of 2022 for posting, accepting the reasons assigned in IA-1 of 2022. IA-1 of 2022 is allowed that the petition be listed in the second.
Some possibility that they will resolve this matter. You obviously refer us to mediation.
Learned senior counsels. Senior only for the petitioner and learned senior counsel appearing for respondent jointly submit that there is a possibility of settlement in matter may be referred to mediation center Bangalore.
One submission could I make, my lord? One submission.
Yes.
I'm appearing, my lord, for Twitter Inc., my lord, that is the one which owns the Twitter platform. I have been served with the hand summons. They have not made me a party, though the reliefs they have asked for.
Sir, when you are not a party, why unnecessary you want to interfere?
They have served summons on me, hand summons on me. So
when you are not a party, where is the question of considering your submission? You tell me.
No, because they have served summons on me. That's the way I wanted to clarify what is happening. Respondent number 2 has been implemented, my lord.
Yes, respondent has filed an application. Who has filed a respondent number 2? Respondent number 2 has filed an application IA-2 of 22 for deleting respondent number 2 from the array of the party. Learned senior counsel appearing for the petitioner submits no objection to allow IA-2 of 2022, accepting the reasons assigned in IA-2.
That's it.
Accepting the reasons assigned in IA-2 of 2022. IA-2 of 2022 is allowed. Respondent number 2 is deleted from the array of the party. Petitioner to carry out amendment and to furnish amended cost title. Learned senior counsel Sri Aditya Sondi for the petitioner and learned senior counsel Pramod Kataway for respondent number 1 jointly submit that there is a chances of settlement between the parties. Matter be referred to mediation. Submission is placed on record. Parties are directed to appear before the mediation center on Twenty-eight at 3 p.m. Priest is directed to forward a copy of this order to the mediation center.
Sorry, my lord, because there was a confusion.
So, filed a petitioner filed IA-1 of 2022, IA-1 of 2022 is allowed.
Confusion ಆಗಿರೋದು ಅದರ ಸಲುವಾಗಿ I wanted to submit.
ಆಯ್ತು ಈಗ ನಿಮ್ಮ ಕನ್ಫ್ಯೂಷನ್ ಕ್ಲಿಯರ್ ಮಾಡಿದ್ರಲ್ವಾ?
ಇಲ್ಲ ಈಗ it's all right, it is fine. So I'm sir.
Who has filed this affidavit? Court has directed to file. Is it the way you draft the applications? Huh? Correct. The court has directed you to file an affidavit. I thought argument made. Case argue the matter. We'll dispose of the matter on merits. I don't want to accept that. La application the affidavit the court has directed to file an undertaking and ತಾತರ ಬರೀತೀರಾ? Come to para 4. Where is the direction? Where is the direction? You tell me. Yes, you argue the matter. No question, you argue the matter. The court will not direct you to file an affidavit. If you want, right? ಅಲ್ಲ ಆ ತರ ಬರೀತಾರೆ ಕೋರ್ಟ್ ಮೇಲೆ ಹಾಕಿ. ಎಷ್ಟು ವರ್ಷ ಆಯ್ತು ಸರ್ ನಿಮ್ ಪ್ರಾಕ್ಟೀಸ್? ಮತ್ತೆ ಈ ತರ ಬರೀತಾರ? ಅಲ್ಲ ನೀವು ನೋಡೋಕ್ಕಿಂತ ಮುಂದೆ ಪ್ರೆಸೆಂಟ್ ಮಾಡಕ್ಕಿಂತ ಮುಂಚೆ ನಿಮ್ಗೆ ಗೊತ್ತಾಗೋದಿಲ್ವಾ? ಅಲ್ಲ ಐ ನೋ ಹೌ ಟು ಡಿಸ್ಪೋಸ್ ಆಫ್ ದ ಮ್ಯಾಟರ್. ಈ ತರ ನನ್ಗೇನು ಐ ಡೋಂಟ್ ಕೇರ್ ಫಾರ್ ಆಲ್ ದಿಸ್ ಇದ್ದು. ಆಯ್ತು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಮತ್ತೆ ನಾನು ಏನೋ ಒಂದು ಪಾರ್ಟಿಗೆ ರಿಲೀಫ್ ಕೊಡೋಣ ಅಂತಂದ್ರೆ ಕೋರ್ಟ್ ಡೈರೆಕ್ಟ್ the court knows how to pass the orders. At the request of learned counsel for the petitioner, let the request of learned counsel for the respondent, let the appeal be listed tomorrow.
Filing counsel or file ಮಾಡಿರೋದನ್ನ 19 filing on 19th March.
ಸರ್ ಫೈಲಿಂಗ್ ಕೌಂಟರ್ದಲ್ಲಿ ಫೈಲ್ ಮಾಡಿ ಇಲ್ಲಿ ಬಂದು ಟುಮಾರೋ. ಅದೇ ಬರ್ತೀರೇನ್ರಿ? ಇದ್ರಲ್ಲಿ ಇದೇನ್ ಗೊತ್ತು? ಆಯ್ತು ಈಗ ನೋಡಿ ನಿಮ್ ಜೊತೆ ನಾನು ನೋಡ್ತೇನೆ. ನಾನು ಪ್ಯಾರಾ 4 ಅಷ್ಟೇ ಇದೆ.
CS Saravana?
For the third respondent in this.
My lords, I'm appearing for the petition, my lords. There's some inconvenience today, my lords. Kindly, the matter may be taken up tomorrow, my lords. A day's accommodation I'm seeking, my lords.
When do you want, madam?
My lords?
When
Tomorrow, my lords. Tomorrow, my lords.
Even on the last date also, you took an adjournment. None appeared for the petitioner on the last date of hearing.
My lords, the difficulty is, my lords, you're unable to locate the file much. Therefore, I'm seeking for tomorrow, my lords. Otherwise, we could have argued the matter.
If you want, I'll send a court file to your office.
My lords, that's so kind, my lords. But just put my person to search, my lords. I will get it, my lords. Kindly tomorrow, my lords.
Unable to place your file, I'll send the court file. And the request of the counsel for the petitioner for the
Please, my lords.
My lord, serial number 34 for the petitioner, my lord. My lord, we will withdraw the review petition, my lord.
They are withdrawing the review petition.
Learned counsel appearing for the petitioner. Learned counsel for the petitioner appearing through video conferencing. Submit that the petitioner seeks the leave of the court to withdraw the review petition. Submission is placed on record. Review petition is dismissed as withdrawn.
Grateful, my lord.
Preliminary hearing matter, serial number 35.
Learned counsel for the petitioner seeks time call after 4 weeks.
This matter, I am for the petitioner. My lord, we have challenged the order first on IA, filed under order 6/17. My lord, basically the respondent has filed a suit for injunction, simple relief of an injunction, restraining, my lord, the relief your lordship kindly look into. My lord, the relief sought is only that he filed a one criminal case, my lord, with regard to against me. To disposal of the suit till he has to be restrained from alienating the property. This is what he has sought in the injunction suit, my lord. My lord, we have objected and we filed an application. 7 Rule 11, this suit is not maintainable. As such, my lord, that relief cannot be granted. It is suit for injunction. Then, my lord, he has filed an application for amendment. The suit was filed in 2014, my lord. The amendment application was kept to be filed after lapse of the 3 years from the date of the filing of the suit, my lord. Therefore, we are objecting, my lord, the relief sought declaration possession, my lord. That is time barred by law. Therefore, the amendment, the relief sought in the amendment, my lord, it is barred by law. Therefore, that amendment cannot be allowed. I realize these certain decisions, my lord. But trial court has taken a note, my lord. Only that you, my lord, he has already filed an application converting the suit from injunction to declaration. Therefore, the suit, the amendment is amendment has been allowed without considering my defense, my lord. What I have been objected and what judgment I have relied, my lord. My lord, I have produced the 3 citations before this court by file of memo, my lord. One is 2016, B.S. Prakash was Gunashekar. That law is very clear, my lord. When amendment is barred by law, the relief sought in the through by way of an amendment, my lord, it is barred by law, my lord. They sought for a declaration, declared that he is the owner, and therefore sought for a possession. Therefore, my lord, first judgment, my lord, I relied on 2016. Case is here 2944 in the case of B.S. Prakash and Gunashekar, my lord. Order 6 Rule 17. The amendment of pleadings principles, my lord, amendment sought for expressly time barred as on the date of rising the plea. Such expressly time barred, such amendment should not be allowed. While claims sought to be put forward through the proposed amendment by raising a new claim had become title barred, namely, if fresh suit is brought for the said relief is barred by limitation as on the date. Such claim through the amendment cannot be allowed. That is what the law is laid down by this honorable court, my lord. The relief is sought, my lord, basically is filed a suit in 2014 for injunction. Myself did in 2010, my lord. He is aware of that all these things. He filed a complaint also. And second judgment also similar, my lord. This court has on the similar set of facts, my lord, has held that, my lord, the time board relief cannot be allowed by way of an amendment. Even Supreme Court also, my lord, in Anmatappa's case, same the law is been laid down. Therefore, my lord, the trial court, the allowing the application by the trial court is against the law, my lord. Such amendment cannot be allowed.
You can take a defense in by way of filing additional written statement.
See, still the my lord, the amendment is we are not filed, my lord. They are not served the copy and amendment. No.
You can file an additional statement, written statement taking a contention that proposed amendment is barred by limitation. Court will decide it.
My lord, in the objection itself, I take that as such a defense, my lord. While they are filing the application, at the time of filing the objection, my lord, I take the defense that.
No, whether court, while considering an application for amendment, can go into that said question.
Yes, my lord, because that proposed amendment, my lord, whether it is a, that's what the law laid by this court, my lord.
Yes.
And injunction suit cannot be converted into declaration, my lord. He has to file, if he any cause of action, he has to file a separate suit. That suit itself not maintainable. Hangagi barodilla. That is our only the contention we have taken. And one more thing, my lord, the suit filed by the GPA holder, he has not been discharged so far. By the time that the plaintiff himself, the defendant respondent here in my lord, he himself filed an application without discharging the GPA holder. That is also we are objected, but the trial court, without considering the same, my lord, allowed the application.
When written statement was filed?
I have filed the written statement, my lord.
11/6/2015.
Yes, my lord.
Application for amendment was filed?
Amendment application was filed, my lord.
2017 November.
Yes, my lord.
So within 3 years from the date of denial.
Title denial, my lord. We are not, that he is not admitted, my lord, he is the owner. I am the owner.
You are denying the title of the petitioner.
Oh, my lord, he is not denied my title, my lord. He has filed, he has now, by way of amendment, he is trying to get in a relief, declare that he is the owner. As such, my lord, he has paid the amount, consideration amount. The amount paid by the petitioner here in Manor for purchasing the properties belongs to him. That is what is like a benami transaction. He is claiming that based on that transaction, my lord. He is not denied my right and title over the property. In the plaintiff itself, he has stated, my lord, I am the owner. The contention is only, my lord, for purchase of that property, he has invested.
Correct, you are well aware at the time of filing a suit. You are well aware about at the time of filing a suit. For the learned counsel for the party, learned counsel for the petition submit the respondent has filed an application seeking filed an application for amendment of claims. He further submits that the proposed amendment sought by the respondent is beyond the limitation. First, he further submits that the petitioner and the respondent was well aware about the
Sale deed 16/2010. That was
sale transaction which was taken place prior to the filing of suit. In spite of having the knowledge that the respondent did not choose to file did not choose to file a suit for relief of declaration, only filed a suit for bare injunction. He further submit that now the respondent is trying to convert the suit for injunction into a declaration. Once he submit, he prays for grant of interim order, add and peruse the record and consider the submissions of the learned counsel for the party. The petitioner has made out a prima facie case for grant of interim order. There shall be a stay of impugned order dated impugned order on IA number 4 dated 7/12/2020 until next date of hearing.
much obliged.
Applying for the petitioner, my lord. The petitioner is defendant number 1 who has filed this particular writ petition, my lord, challenging the order of allowing the amendment application filed by the plaintiff, my lord. The plaintiff instituted suit for declaration and permanent injunction, my lord. He instituted on 26th February 2007, my lord. My lords would find it at Annexure B, page number 24, my lord. Annexure B, page number 24. The defendant number 1 is there, my lord. And the relief, my lords, would find at page number 31, my lord. Relief what has been sought for declaration and consequently permanent injunction, my lord. And with respect of one particular sale deed of the year 1996, which was executed in my favor as per the decree of this honorable court. Thereafter, my lord, on 2/3/2009, I filed written statement. Annexure C, page number 33, my lord. Page number 33 is the written statement. Typed copy of the written statement, my lords, would find it at page number 41, my lord.
Application was filed prior to commencement of evidence.
My lord, after posting the matter for judgment, my lord, he filed an application for reopening of the case. And then, my lord, he has filed this particular application on 13th September 2021. Annexure H, page number 88, my lord. And the learned... My lord, I have sought for stay, my lord, because it was almost, it changes the entire nature of the suit. Now he is seeking for the declaration possession. Earlier it was declaration and permanent injunction. Now the entire nature of the suit is changes. In the year 1996 itself, I was putting
that you have dispossessed him during pendency of suit.
That is his contention,
The
my lord.
subsequent event.
My lord, that is
the subsequent event.
My lord, with respect of that, my lord, he should mention in his application for the proposed amendment on what date he was dispossessed. I request my lords to kindly take annexure H for a moment, my lord. If my lords takes annexure H for a moment, in the proposed amendment, cleverly he does not mention when he was dispossessed. Annexure H, my lord, proposed paragraph is paragraph number 17A. And in that continues at page number 88, 89 also. There cleverly he does not mention when he was dispossessed. Then what is the cause of action for the proposed amendment? It is a cleverly he is seeking this particular relief. I have relied upon one particular judgment, my lord, that is of the year 2018 SCC Online Karnataka 3059, my lord. That is Shardamma versus SR Manjunath. In this honorable court, in similar circumstances, has considered cleverly not mentioning the date of dispossession in such circumstances.
Take out a notice.
My lord, my submission is that, my lord, I seek for a stay, my lord. The stay of this particular. Sorry, my lord. The reason is that, my lord, the court is.
If you want a disposal, I'll dispose it of, no issue.
My lord, my only predicament is. Yes, my lord, I will argue the matter.
I'm dismissing it now only, I'm telling you.
Yes, my lord, because unless notice, because it will create problem, my lord. The trial court is posting the matter on everyday basis for that reason, my lord.
Yes.
Yes, my lord. Annexure B, my lord, my lords would get, my lord, the plaint, my lord, page number 24.
Page number?
24, my lord.
Yes.
The defendant number 1, my lords can see the relief what has been sought is at page number 31, my lord.
Yes.
The relief is the first relief is with respect of declaration, my lord. The second relief is the consequently declaring that the sale deed obtained by the first defendant dated 3/1/1996 in respect of suit survey number to an extent of 22.5 guntas on behalf of the defendant from the hands of Office of Second Municipal Court, Bangalore, as per ex parte decree so and so, and by virtue of execution proceedings is not binding on the plaintiff. Of 15 gunta as per registered sale deed dated 16/4/1998 by the plaintiff in respect of the suit property, my lord. Then, my lord, I request my lords to kindly take the written statement, my lord. The written statement is at next page, my lord, annexure C, page number 33.
Yes.
Then, my lord, the typed copy of the written statement, my lords would find at page number 41.
Yes.
Then, my lord, I have specifically in page number 42, para number 4, my lord. At next page, my lords, at page number 43, I have specifically mentioned that, my lord, by virtue of MR 5/9798, I have been in possession of the property. It is an open land.
What is the period of limitation prescribed for filing a suit for possession?
My lord, for the period, for the possession, my lord, it is 12 years, my lord. Yes, it is 12 years, my lord. Then, my lords would get, my lord, the issues which has been framed. Annexure D, page number 49, my lord.
Yes.
The issue number 3, my lord. Whether the plaintiff proves his possession over the suit scheduled property as on the date of the suit. Because, my lord, I specifically contended before the trial court that he is not in possession of the property. I am in possession of the property. This particular.
When you filed a written statement?
I filed the written statement on 2nd March 2009, my lord.
When an application was filed?
An application was filed on 13th September 2021, my lord. MR entry was made in the year 97-98, my lord. Revenue entries were made in the year 97-98.
The learned counsel for the petitioner. Issue notice to respondent number 1. Notice to respondent number 2 is dispensed with at the risk of the petitioner. Third, the learned counsel for the petitioner. Learned counsel for the petitioner submitted the petition has filed a written statement in the year, filed a written statement on 2/3/2008, wherein the petitioner has contended in para 4 of the written statement stating that the petitioner is in possession and enjoyment of the suit property as per the sale deed executed in his favor by the court to an extent of 22 months as the trial court framed the issues on 11th December 2019. The petitioner knowing fully well that the petitioner and the respondent knowing fully well that he is not in possession of the suit property. He filed an application for amendment of claim on 13/9/2021. The counsel for the petitioner submit that the proposed amendment sought by the respondent is barred by limitation. First of the said aspect was not considered by the court below. Hence, he placed the plant and entry fair. Third, encourage the records and consider the submission of the learned counsel to the petitioner. The petitioner has made out a prima facie case for grant of interim order. There shall be a stay of further proceedings in OS. There shall be a stay of impugned order. There shall be a stay of operation of impugned order till next date of hearing.
My lord, one submission, my lord. I have this date of filing of written statement is 2nd March 2009, my lord. 2nd March 2009.
2009.
Serial number 38, Sri G.S. Srikante Gowda.
If you notice correspondent in addition to permit cooperate with the counsel appearing for respondent before the trial, if the petition be listed in the 2nd week of March. And there shall be interim order as stated for permit. This is a copy of the petition along with annex with the learned counsel for respond number 1. Is the learned counsel for the petitioner submit that notice to respond number 2 to 6 may kindly be dispensed with. Submission is placed on record. Notice to respond number 2 to 16 is dispensed with at the risk of the petitioner. Learned counsel for the petitioner submit that the respond number 1 has filed an application seeking for amendment of claim. He further submit that the trial court, without assigning the proper reason, has passed the impugned order. Mr. Perry, the order impugned order. The trial court has not assigned any reason. The trial court has found a cryptic order, and the petitioner has made out the notice for grant of impugned order. There shall be a stay of operation of impugned order till next date. Impugned order. Impugned order. Impugned order. Yes. Go ahead. Okay.
Serial number 40.
Here for petitioner in this matter, my lords. Lords, against this writ petition is against my lords and not considering my lords for ad interim injunction, my lords. So far as my lords,
the trial court.
My lords, this is matter.
The trial court.
My lords, there is my lords a hindrance, my lords, in my lords use of premises, my lords. May kindly see my lords page number 33, my lords, annexure G, my lord, for a moment, my lord. I would pursue, my lords, the car parking allotted to them, my lords. We have no objection. What is allotted to them, my lords?
Till the appearance of the defendant. Can't you wait till the appearance of the defendant?
Lords, very purpose of seeking ad interim injunction would defeat, my lords.
Court has felt that it is not proper at this stage.
No, my lord. Court refuses on count, my lords. Multiple prayers are sought in IA, my lords. My lords, I restrict only, my lords, one prayer, my lords, that other than the 12 car parking, my lord, let there not be parking anywhere else, my lords. May kindly peruse photographs, my lords, entire obstruction because they are running a car showroom, my lords.
Yes, sir.
Page 67 and 68, my lords, could peruse, my lords. And 69, my lord.
How many prayers can be sought in one interlocutory application as per civil rules of practice?
One, my lords, restrict to one, my lords. At least one prayer could have been considered by the trial court, my lord. Court have made a note that, my lords, 12 car parking is allotted to the vendors of my lords.
Come to page number 101.
Please, my lords.
Yes, read from therefore.
Therefore, consider available matter. This court opinions that the present IA may be considered only after appearance of the defendant, even considering the fact now fresh SOP guidelines have been dated, so are in force, and therefore it is just and proper. My lords, I am not only, my lords, may kindly pursue, my lords, in page 33, my lords, and annexure G starts, my lords. And the relevant page
We are not on merits. We are not on merits.
My lords, the injunction, what I am saying, my lords, in restraining, my lords, in respect, not restraining in respect of their portion, my lords. It's only in respect of other than their portion shall not, my lords.
Wait till the appearance of a defendant.
The very purpose would defeat, my lords. I am not seeking, my lords, any of their rights being obstructed, my lords. I just to protect the interest of other portions in the building, my lords. They are finding an inconvenience because of these car parking.
Take out a notice.
In this case, I appeared for the petition, my lord. This is a plaintiff's writ petition, my lord, that the suit for injunction was filed. But both the courts have rejected only on the ground that, my lord, the agreement of sale is non-registered.
Without a notice.
Please.
You can notice correct.
Respondent, my lord. Request your lordship to grant in week's time, my lord. I had put a word to the counsel appearing for the petitioner. I want to place a few of the documents which were placed before the trial court.
What's the construction has been stopped by virtue of an order passed in the miscellaneous appeal when the injunction application was rejected by the trial court. The dispute is in a very narrow compass. Status quo will be as good as preventing me from putting up construction, because the injunction is not to put up construction.
They want to put up construction in my property, my lord. I want to place the documents which were placed before the trial court by the plaintiff. Those documents were not placed along with the writ petition, my lord. This is no objection brief for me. I asked the party to obtain the copies of the document. Let it be taken up during the next week, my lord.
Second week of.
There is an urgency for me in this matter, my lords. My construction has come to a standstill. May I request your lordships may have this matter in first week, not subject to your lordships' convenience.
Second week.
Very well.
Please.
Further hearing, Ravi Shankar.
My lords.
In further hearing, do you appear? Serial number 50.
Serial number 50, sir, for further hearing.
No, my lords, I am not appearing in this matter.
No, you appeared and argued the matter on behalf of
Parashuram.
It's order 20 compromise decree which was set aside in the without voting in inquiry.
Yes, my lords. I have appeared in that matter, my lords. I have appeared in that matter.
No,
that matter could be disposed of. That I'll appear, my lords, because today maybe he has not given me instructions of the matter having been listed, my lords. But I am appearing in that matter, my lords. The matter has been argued substantially, my lords. The only question is, without holding an inquiry.
Yes, pass over, Ravi Shankar.
Very well, my lords. Very well.
Yes, Subramani. Direct the trial court to dispose of the suit. Now the matter is posted for arguments. Even if it is remanded, then again the suit will come to standstill now. Correct, sir. If it is not posted for argument, I could have remanded the matter to the appellate court. At the most, we can direct the trial court to dispose of the suit. Issue rule. The petition will be disposed of. Instead of that, if you want to keep the matter pending, you can. If there was any interim order from 2016, then dismissal. Concurrent finding ಇದೆ ಸುಮ್ಮನೆ ಏನೋ ನೋಡೋಣ ಅಂದ್ರೆ ನೀವು ಅದಕ್ಕೆ ರೀಸನ್ಸ್ ಕೊಟ್ಟಿರ್ಲಿಲ್ಲ ಅಂತಂದು ಏನೋ ಮಾಡ್ಬೇಕಂದ್ರೆ ಬಟ್ ಮ್ಯಾಟರ್ ಇಸ್ ಪೋಸ್ಟೆಡ್ ಫಾರ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್. Petitioner agreed by the order on IA number 2 dated 20th/12/2014, passed invoice number 222 of 2011 by the second additional civil judge and JMSC Kadu, and also order passed in MA number 5 of 2015, dated 16 December 2015 by the senior civil judge and JMSC Kadu, has filed this writ petition. Brief facts leading us to filing of this writ petition are as under. Is to the petitioner filed a suit for permanent injunction, invoice number 222 of 2011 against the respondent. In the said application, in the said suit, the petitioner filed a IA1, IA number 2, seeking an order of temporary injunction, restraining the respondent from interfering with the peaceful possession and enjoyment of the suit scheduled property. First of the trial court, the said application was opposed by the petitioner respondent. The trial court, after hearing the parties, rejected the application filed by the petitioner. First of the petitioner agreed with the order on IA number 2, passed by the trial court, filed the appeal in MA number 5 of 2015. First of the appellate court, after hearing the party, dismissed the appeal filed by the petitioner and confirmed the order passed by the trial court. Hence, this writ petition for the learned counsel for the petitioner and also learned counsel for the respondent. Learned counsel for the petitioner submit that the court below have failed to consider the contention of the petitioner and also documents produced by the petitioner. He further submits that the petitioner has produced some document before the appellate court. The appellate court has overlooked the said document and proceeded to pass an impugned order. Respondent has produced some document before the appellate court. The appellate court, without considering the said aspect, has proceeded to pass an impugned order. Hence, on this ground, he submits that the petitioner is in possession of the suit property. First of the both the courts below have committed an error in passing the impugned order. First of the control and counsel for the respondent submit that the courts below were justified in passing the impugned order. He further submit that both the courts below have concurrently recorded a finding of fact against the petitioner. First of he further places reliance on the judgment of the Honorable Apex Court in case of Radhesham also so and so, reported in so and so, wherein he submit that scope of interference under Article 227 is limited. Hence, on this ground, he prays to dismiss the petition. Heard and queries the reports and consider the submissions of the learned counsel for the party. Queries the records. It is the case of the petitioner that petitioner is claiming that she has purchased the property under register sale dated 28/8/2006 and is in peaceful possession and enjoyment of the suit scheduled property. It is contended that the petitioner is a poor agriculturist and respondents are powerful persons. The plaintiff has produced a copy of register sale dated. The petitioner has produced a copy of register sale dated 2/8/1941, executed by Virupaya in favor of Ramaya, son of Ramdasappa. First of, from the perusal of the register schedule, the recital of the said document discloses that vendor of Veerpaya had acquired a right over the survey number 205 as per the recital mortgage deed dated 1/7/1929, and accordingly he has sold the said property to said Ramaya to support the courts below have concurrently recorded a finding that the petitioner is not in possession of the suit property, and further the petitioner has failed to make out a transmissive case for grant of interim order, and also considered the balance of convenience and irreparable loss. First, that the courts below have concurrently recorded a finding of fact against the petitioner. First, in view of the law laid down by the Honorable Apex Court in case of Radhesham versus so-and-so, wherein the Honorable Apex Court held that scope of interference under the supervisory power under Article 227 is limited. Full stop. Both the courts have concurrently held and recorded a finding against the petitioner. In view of the law laid down by the Honorable Apex Court, I do not find any grounds to interfere with the ensuing orders. Accordingly, writ petitions are this total 3 writ petitions.
I apply for the respond number 1, 4, and 11, my lord. My lord, this is a suit of 1982. 1982 year, the suit has been filed, the FDP filed in 2003. At the fact, your commissioner has submitted his report. At the fact end of that, at the time of writing final degree, they have filed the application to implement them as the necessary parties in this case.
The petitioner is a trust sponsored by the government social welfare department. And another source that the partition and legal issue was passed and finally of the right. I came to about the tendency of and filed an application in the of the content. So I like that one of the items of property, which is this subject matter of document, and where the suit is carried in the amount of relevant and not operating. So far as the ultimate subject matter property, that application came to be rejected. It is which I am before this comment for. The issue involved is not whether an agreement holder having a right, so far as the agreement is concerned.
This is a copy of interim order.
Yes, I made the prosecution copy of interim order at page number 95. Page number 95. While drafting this order may not, the trial court has considered my suit. It's related to so many things. It will have an adverse impact on my suit also, this order. I take the lordship to the order. The applicant proposed respondent has filed an agreement of Article 210. It is contended that the applicant proposed respondent was land. Building area number 140 and then to serve most of the it is also contended with the applicant and complete sale consideration. Contended with the applicant they are necessary party. I have gone through the entire right. As a waste of the respond number 2, A, and 2 others are challenged with the case. This is 7/1959, but the shooting was right at after last. These are the observations. Without even
We'll make it very clear. The trial court was disposing of OS number 26944 of 2011. Do not come under. Do not come under.
This is the order. Now, the question we want to solve for is whether I have any.
Is the suit for party? What is the nature of suit?
Suit is for partition. This for partition among the jurors. I am a third party in Gopal as this particular but I have got a right. The Supreme Court was responded. Where an interim order is also passed, not to relevant, and I am in possession of the particular land. Now, if this order, I am not part of this proceedings. My right will be revoked because the land is pending.
Correct, but you are claiming on the basis of agreement of sale.
Yes.
Proviso to section 34 of 54 of TP Act. What it says?
I am a necessary and proper party. I cannot do. The first statement below. In this case, first statement, 1998 is online.
The judgment.
This is also under the bill, independence of the suit and the negative under the bill, though it is not displayed, as comes to report and said that I am because one of the properties equal to me.
Yes, sir. Will stands on the same footing as that of an agreement for sale.
Any interest right is created or not, that is the question. Now under the agreement it is a contract where an interest is created. Where an interest is created, though not the right. Ultimately it is spiritually created. So the right interest in the power of the right later. But the interest is created in the agreement. Therefore the contract act binds the parties. My submission is in this case you are
Ultimately, if a petitioner succeeds, he can file a suit for general partition.
See, what happens is
Ultimately,
finally is passed.
correct. You are
then if I succeed in the suit, then we come from number one. Number two, that has to be avoided. Number two,
when you get the right,
this site is bifurcated and
please first try to answer. Your claim is based on agreement of sale.
agreement of sale and
That is pending. Until you have purchased the property, that is undivided share. One of the it is undivided. No? Property is not yet divided. So if in a suit for partition, if a property is divided, whatever the share your vendor gets, that you are entitled for it.
But practically, it may not be possible for me to get it. The reason is, if this particular property is given to three persons, for example, and they to create some third party interest after the final decree, then
Correct.
where I am?
Correct. When you purchase undivided share, whatever the share your vendor is entitled to, that extent only you are entitled. You cannot get more than the property which.
Number two, I have got an interest. Number three, if this particular property is divided amongst the sharers, is in me, then to get this particular property is very difficult. That is the reason. At this stage itself, I may be permitted to come out. And this is
You already filed the independent suit. That will bind out the vendor.
That will bind up and practically it will be difficult. That is the proposition. That is the proposition. It's very difficult for me. That is the reason. That is the reason I came to not so. 11, 12. 11. And when this suit, though it is preliminary degree is passed, it's not applying penalty. Only after final degree is passed, that is the penalty. Now, this in all practical purpose, in law, suit is pending. This partition suit is pending.
Final decree is also nothing but a continuation of our original suit. Not only that, even if a FDP is there, there is no provision under the CPC to file an FDP. Which is the provision to file an FDP? Please show me, sir. The 20 rule 12 and 20 rule 18. That is not applicable.
I am not on that.
No, I'm telling you, you have said that there is a provision for FDP.
I am not on that.
Correct.
I am not on that.
Yes. Read para 12.
The order explanation is not to general or ordinances agitated is right to the property is right not to be free without the implement of penalty or order on such a order then is right that where we go at any stage either upon or for the either of the party satisfaction and any person have been joined as the principle of credit or whose presence before the court, according to it, is never unique and upon the all the questions is not in the suit. It will be order of if the person who in application for implement, and it is that is necessary and what have been completed. All those things is totally satisfied that what have been completed and have not been completed, the court may order this completed. This power of suspicion or suspicion to direct implement may be ordered either so modo or an application being at any stage of the proceedings. At any stage of the proceedings indicate no final decree has been passed in the suit going on and proceedings are not closure, then at any stage of court, it may.
So correct, sir. It is settled on. It is settled on that an application can be correct. Provided if a sale deed was executed, then whatever the contention which you have raised could have accepted. But proviso to section 54.
In the incident case, the property, one of the items of the property was bequeathed. And during the trial, the pendency of the suit, then he wanted to come on record. There also it was not.
Suppose in case if a suit came to be dismissed, you were sued for specific performance.
The second further question.
Then?
Therefore,
So you were right.
Therefore, my lord, my humble submission is, and even assuming for a moment, even equitable partition case, if I go before the court, and this particular property is omitted in the final decree proceedings, the intended disposal of my soul, you will not have that. You will not have that. Ultimately, they will succeed. They will succeed. On the other hand, if this particular property is amongst several shares, is recently partition and third party interest is created, then it will lead to
Already injunction order is granted in your case, your suit.
Therefore, now it is more important to be as a source, the party respondent.
Then there will be no end for it. Then there will be no end for it. Then there will be no end for it.
No. Ultimately, the court can consider whether the right is there or not. Maybe background of my soul. See, to come on.
Correct, sir. You must show that you have got a right. First, you must establish that you have got a right. Then, yes.
Under which I am entitled for a specific performance. Prima facie case is made out of the trial court, and the trial court passes the judicial order, and itself indicates that how I can make. Right of interest, maximum I can say. And what is the sound is whether by coming into this particular proceedings, whether the trial court can actually finally adjudicate the rights of all the parties. That is very important. That is very important. Going me at the threshold itself cannot be correct. And the second, in this particular case, it was slow to come on record. In Washington, I can see para 27. Very short. The question related to the merit of the applicant claim, right, as a person of the defendant of on the basis of the release alleged, will be determined effectively when the course of prior claims. Here also, on merit, and it will avoid the multitude of the legal proceedings and tools and harassment.
Whether any suit was filed by the beneficiary in this case, whether any suit was filed by the beneficiary in the judgment which you are citing.
No, here the bill was produced. Here I am in a better position because my right is considered and entry not discussed.
Yes.
I am in a better position. There only a bill was produced and an application for increasing the file and the court center. Though it is not fully and better determined so far as the right of the bill, he is entitled to come on record. Here my submission is a little inferior right compared to my right. Because my right, prima facie, has been considered to the trial court.
Yes.
Next judgment record, that is the 2010 SEC 719.
There was a sale deed in this case. There was a sale deed in this case.
There was a sale deed, he is in a little better position because right is this case.
That reason I told you, provided if a sale deed was in your favor, whatever the argument which you have addressed, that could have accepted.
The people under the different documents will get right. Certainly some may not be motion to say that our better price it for the dealer say, but I have got an interest and it's a contractual obligation.
Correct, sir. Your purchase undivided. That agreed to purchase undivided.
What this honorable court has to say is, by coming into the financial proceedings and to make a submission for the court, whether their interest is going to be less. Certainly not. And to consider my application, what timeline is. Timeline is. Immediately after coming to know, I have tried this application. Therefore, if any tinge of right is
That is so. When a memorandum of agreement was executed.
that is in the year
79.
There was a clause. The condition was imposed. Therefore, and in this particular application, that cannot be considered because that is subject matter to the trial court is splitting.
That reason I told you, go and just a remedy in the suit for specific performance.
That I have taken, that I have taken, and injection now is set out for trial also.
That is the reason why trial court has rejected your application. The memorandum of agreement was in the year 1979. You filed a suit after.
That's again a wrong thing. I will write the address of particular. This court cannot adjudicate. And say anything.
No, you only say that your right has to be adjudicated in this.
What has to be considered when deciding the application for improvement is only whether I am proper and necessary party, whether by coming into the proceedings I can assist the court or not, whether coming into the other side or not, whether it avoids the possibility of. These are the 4 or 5 parameters. Not commenting on my suit
Yes. With kind permission, my lord.
And my lord, this judgment, the Honorable Supreme Court.
Yes, he has purchased during pendency. He has purchased during pendency of suit. Doctrine of mispendency.
Rightly asked the question. Section 2, take care. But also do not be considered to be number 5, paragraph 5. Paragraph number 5 of the second judgment. Section 52 deals with the transfer of the property pending suit. In the instant case, not dispute the first respondent.
They can come as an assignee under order 22 rule 10 if a property is purchased during pendency of suit. If a property is purchased during pendency of suit, they can come under order 22 rule 10 of CPC as an assignee.
Assignee. If it is assigned, we have a document there. Straight away they cannot come. We have an assignment deed. Actually, otherwise they cannot come.
Yes.
And in this particular case also, the analysis, we therefore satisfied the order of the court and order of another third judgment was
Yes.
There are 4 document ID. Here also, section 54 consider. Here also.
Page number? Page number? Page number? Para 4 of the judgment of? There are 3 judgments. There are 3 judgments. Only 3 judgments. That is Dhanlakshmi and others. First statement. Yes. Yes, read paragraph 4. Yes. Under the sale deeds. No, read under the sale deeds. Not under the agreement.
If it is yes, though it will be adjudicated, prima facie, then I am proper and necessary part the proceedings. Yes, again,
With kind permission, my lord. My lord. Sorry, I am not. Okay.
The only prayer made by the saving and they have quite better and also and also probably also then what I said, they are effects of here also quite succeed.
File an application in the FDP.
Then I cannot, this will be over. The FDP will be over. FDP will be over. See, for example, this will be equal to 10 persons, 10 persons will be there. So, one of the persons, they create a third party, right? Sell it. Then how do I take it back? Again, I will try to look for those persons. See, that is the reason to avoid the multiplicity of resources. So why do you think we are zone? I am a master senior partner, proper party. Look it says, the appellant alleges that son of so. By take away. So, question for consideration. Whether the High Court and the government and the revenue authority provide in the yes, voting of the appellant, more opportunity to ask for parties say the Section 50 of the Transfer of Property Act, mode of place found that the transfer interest, this is very important, interest in an immovable property is the subject matter of the vote of any of the parties. The vote will be bound insofar as the interest is concerned. Here also, the interest is created. The proceedings is so. Such a transfer is a representative of the interest of the party who has acquired the interest. Who take up are ready to really recognize the right of the transferee to be treated as a party and to be heard before the other made. If that it does not apply to be treated, he may suffer by default on account of any order of proceedings. Here also, if I don't the order is passed.
Correct, sir. In this case, a sale deed was there. In your case, only an agreement of sale. It is yet to prove it.
Right, title and interest, these three important aspects are there to say that whether what a right to come on record. If I establish before that I have interest by way of agreement. And the suit is both are pending before the Supreme Court only. But if the applies to be treated as a party to be heard. He has got to be read and heard. He can also prepare an appeal. It is an order made in the fact question. But with the view of the appellant court, where he is not already brought on record, the position of the person whom is very important. The position of a person on whom any interest has evolved on account of a transfer during legislature or proceedings in some somewhat similar to the position of an heir or a legatee or a party there during the legislature or a proceeding or any of these takes over the assets of such a party on this property and may or a legatee or not official or a transferee can participate in the execution even though their name is not. If they apply to the court to be treated as party, they cannot be turned out. The collector who has to under section has no doubt to divide it into important but party to such a degree raise giving some way about who there is no dispute he put up his hand and returned to the grave. He did not do so. He may believe what is here and is the party. Similarly, he may, when there is no dispute, to allot the share of the seat party. In the case of insolvency of the party, bring the analyzing. Yes, sir. In case of a transferee pendant right, also if there is no dispute, the collector may proceed to make department property in an equitable manner instead of taking the claim process. After all, a transferee the party of the property, which is the subject matter, then it is also there is no dispute. The party can ask for I succeeded in you going on. I succeeded in you. I can go to the court and say, completed and already better. I cannot do that. There is no dispute. The party can ask for the party. It transferring from him. This one can also such a construction of advance the cause of justice. Advance the cause of justice. Otherwise, see, every case, the party is parties are created as a problem. Already constitutes interest in property. Some interest. This is very important. Some interest. Property pendant trade. The land has goes to property. Therefore, back even though there may be no revolution, transfer, in any such case where there is no dispute, he would neither be violating or transgressing the law. This action would not be whatsoever. On the other hand, it would be in conformity with the intention which has placed the court of action and the
Crux of the judgment. Crux of the judgment is if he has got the right, he will become a necessary and proper property.
Yes, here I have got a right. Here and that is pending before the court. Prima facie have made out an intention order and that is successful. Therefore, my emphasis is sufficient. So, if I will go before the court and I can enter which is has to be considered equitably. Otherwise, my right will be and in the interest of justice, more particularly, this is in the interest of justice. So, because so many parties are, what has to see justice? If I come before the FTP court, no prejudice is going to be passed to them. We want the FTP court maximum can resolve. They can resolve this particular property and partition or other property. And ultimately, reserving liberty, that can be happened. Then not harm them. If I succeed, I get it. If I don't succeed,
That's it.
therefore, my humble submission is the order which is passed by the trial court, more particularly, commenting on the which is pending before the trial court. I
What trial court has commented on university? What is the observation?
observation not
It is only a submission. It is only a submission of the counsel for the plaintiff. Filed a suit after 39 years.
after that observation. For a moment, there the court has not asked the litigation is concerned. That also considered there. It is considered that the application respondent need to know about the panel at a time of filing the suit. Then also he has filed a year after that 5 years. Whenever I came to know about this case, immediately I filed it. The remedy is available to the court itself, which has been filed in the so these observations, 32 years, all these things. See, that has been considered there, and in interim also they have been discussed after hearing it. Therefore, the prima facie made of a case with the trial court to go on record.
Yes. My lord, admitted it is agreement has been executed, claims to be executed on 26/11/1979. My lord, the respondents have filed the suit for partition during the year that is on 7/7/2082 in OS number 2103/1982. My lord, the said suit has been disposed on 7/11/2002. During this period, the petitioners have not whispered about this agreement. But again, the appeal has been filed and it was disposed on 31/5/2010. Even during this period also, they have not whispered about this agreement. My lord, it is respondent number 7, one of the, there is a Vijay Lakshmi Ramana. In the suit filed by the plaintiff in OS number 26,944/2011, the PWN specifically admitted that ಒಂದನೇ ಪ್ರತಿವಾದಿ ವಿಜಯಲಕ್ಷ್ಮಿ ರಾಮಣ್ಣನವರು ವಾದಿ ಸಂಸ್ಥೆಯ ಅಧ್ಯಕ್ಷರಾಗಿ ಇದ್ದಾರೆ. It is nothing but a collated suit. This Vijayalakshmi Ramanna, being the respondent, she is trying to dodge the proceedings by creating document after document. My lord, this and also I have established this and furnished the document. My lord, kindly peruse page number 18, my lord. 18 of the application, that's a document. 18, my lord.
Yes.
The second witness, Larita Subbaratnam, kindly peruse the address mentioned in that to that second witness, my lord. 2/2, Kariyappa Road, South Cross Road, Basavangudi, 2004. My lord, kindly peruse, my lord. This document is prepared in the year 1979. During the year 1979, there was no by name Kariyappa Road. I have obtained the certified copy from the concerned authority BBMP. They have specifically stated that ಈ ಸಂಬಂಧ ಕಚೇರಿಯಲ್ಲಿ ಲಭ್ಯವಿರುವ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ಮಾಧವರಾವ್ ವೃತ್ತದಿಂದ ಕನಕಪುರ ರಸ್ತೆ ಮತ್ತು ರಿಂಗ್ ರೋಡ್ ಸಂಧಿಸುವವರೆಗೆ ರಸ್ತೆಗೆ ಎಸ್ ಕರಿಯಪ್ಪ ಎಂದು ಸರ್ಕಾರದ ದಿನಾಂಕ 9/9/98 ಆದೇಶದ ಅನ್ವಯ ನಾಮಕರಣ ಮಾಡಲಾಗಿರುತ್ತದೆ. This name has come into existence only during the year 1998. My lord, this document has been established and prepared in 1979. That S. Kariyappa was not, he was alive during the 1979, he died in the 1980, he is from Karnataka. Later on, it is named as S. Kariyappa. My lord, these are all the and they have several documents to show that have even one more case is pending before the courts, my lord. They have created a will. They have created the agreement of sale. Now, my lord, at the time of 1979, the value of the property was 17,000. Now it is more than 35 crores, my lord. That's why this Vijay Lakshmi Ramana, who is the second, that is seventh respondent in this case, she is colluded with this petitioner and created document after document, and they are dodging the proceedings. Well, in spite of it, my lord, the FDP proceedings has been filed during the year 2003 after disposal of RFA. My lord, this application is filed during the year 2016. They have filed the suit in the year 2011. What they are doing all this the time, my lord? And even the trial court has specifically stated that in the while passing the order, my lord, in the page number 96, my lord, the remedy is available to the applicant, proposed respondent in the suit itself, which has been filed by them in OS number 26,944/2011. Even, my lord, this even 26,944/2011, which is filed by the petitioner, it is before the civil court. Now it has reached the finality. It is posted for the defendant has been examined. It is posted for further cross-examination of defendant, my lord. After the examination of defendant, their case will be decided. Now, at this belated stage, the intention of the petitioner is only to dodge the proceedings. And these proceedings, my lord, the application is not at all maintainable, and the petition is liable to be dismissed, my lord.
What do you say on the judgment cited by him?
My lord, my lord, first of all, they are not at all in possession of the property. When they are not possession of this property, this judgment is not maintainable in this case.
Yes. Yes, sir.
Because they says, my lord, this is the single unit. This is a single unit, 16,000 square feet this property, my lord. It is a single unit. They says they are in possession of the property. There's no bifurcation in this property. This Vijay Lakshmi Ramana, the respondent number 7 is in possession of this property to the entire property.
Respondent number 2A.
Central Social Welfare Board Chairman. They are saying that I have got interest with some other person. Okay, that we are producing documents.
Sir, who has executed an agreement of sale in your favor?
No, you have interest. That is the
Who has executed the agreement of?
Venkatappa has executed this agreement in favor of this trust. It is sponsored by the state government, and it is a state government sponsored trust.
That's one more submission, my lord. One more submission, my lord. During the year, I have established in the case that during the year 1978 itself, since 1975, this Venkatappa was suffering with paralysis. He was not in a position to put his signature. And so the signature made in this document is
If I am not in possession, how can the injunction has to be granted? Injunction is operating. I am in possession, and the factory is going on. Building is there, and documents show that I am in possession of the bill.
after the disposal of RFA, they have created will, they have created the agreement of sale. Because of collision of this one of the proportional, they specifically admitted that this Vijay Lakshmi Ramana, who is the seventh respondent, was the president of this association organization. She is deliberately dodging the proceedings.
The government sponsored.
Time is the essence of contract.
I know not the essence of the contract. And there was a condition. You not going to see the
Come to clause number 10. Come to clause number 10.
There is a
Page
direct
number
ruling, my
7.
lord. There is a direct ruling of 2005 Supreme Court in Kasturi versus Dia Parimal. There is a direct ruling. 2005 Supreme Court, Kasturi versus Hridaya Parimal. Direct ruling.
Page number, sir?
Page number, party's name I remember, page number I don't remember.
Party's name, heli, sir?
Kasturi versus Hridaya Parimal. 2005 Supreme Court.
What is that, sir?
Directly on the point of agreement to sell, whether he has got a right to come in partition suit or not. He can't enlarge the issues.
So application
Direct
cannot
ruling.
be entertained.
Direct ruling, there is a bar. His remedy is elsewhere, not in the original suit.
Yes.
Direct ruling is the 2005. In fact, that has been reported by Justice Arvind Kumar.
Yes.
I argued the case and Justice Arvind Kumar reported between me and Mr. Telepathy.
Yes. Thank you for assisting the court, sir.
I'm sorry, my lord, because it is
It's okay, it's
not
okay, you are assisting.
I was just joking.
Yes.
Para 5, even the obligations from their part are not
ಆಯ್ತು ಬಿಡಿ, ನೀವು ಮಾಡಿ ಮತ್ತೆ ಯಾಕೆ ಅದಕ್ಕೆ ಅದು ನೋಡೋಣ ಅಂತ.
possession is admitted under the element itself. When the possession is concerned, my lord, the agreement itself.
Correct, sir. Already injunction is granted in your favor.
Possession is admitted there. The first party or the successor of the investment or any other no right to disturb or access second party to the civil property. Second party has no right to enjoy the act for.
Yes.
The first party effort is desired that it is not possible to immediately.
Whether those things are required for consideration, for considering order 1 rule 10 CPC. Then why unnecessary? Why unnecessary or?
And commented on this particular code. So other side has taken up that particular contention and by duty to counter it. That is the reason.
That's all.
That's all.
Third, repetition dismiss, reason follow.
Please, Mulad, I appear for Mulad for the
respondent.
Mulad, the impugned order, my lord, would see it's at in page 62. 62.
Yes.
It's a very short order. I should just read it for my lord's kind of appreciation. IA3 filed under Order 7, Rule 11, read with 151 CPC by the plaintiff is hereby allowed on payment of cost. Plaintiff is permitted to produce the documents. PW1 present and examined in chief. Documents exhibits P1 to PC8 mark. Now, my lord, this is one. The documents at serial number 6 and 7 in the memo submitted along with IA number 3 will not give the sense of evidence as provided under Section 3 of the Indian Evidence Act. Further, the alleged document is not having any proof to say that it is counterpart of an original document as stated in Section 62 of the Evidence Act. Hence, the documents are not marked. Now, my lord, these two documents, my lord, are described by me, my lord, in my writ petition, which my lord would see at ink page 7.
Para number 6.
Please, para number 5, my lord, para number 5.
Yes.
Para number 5. These are the two documents at serial number 6 and 7 in italics. Notings made by the father of the petitioner in his own handwriting on a piece of paper pertaining to the transactions which had with PVA Kadar, the earlier tenant. Notebook which was maintained by and written by the father of the petitioner, which contained various notings relating to the transactions which the petitioner's father had with various persons pertaining to the properties. Now, my lord, how I do not understand how the learned judge could say that these notings which are made on a piece of paper and on a writ petition is not a document within the meaning of section 3. My lord, what is document? I have reproduced section 3 at ink page 9. Ink page 9. Suit is for ejecting the tenant who has filed a counter suit for declaration of his title by way of adverse possession. A document means any matter expressed. My lord, in page 9, I have produced document. Document means any matter expressed or described upon any substance by means, letters, figures, or marks, or made or those intended to be used for purpose of recording. So both the documents are documents within the meaning of section 3. Both are originals. Now, my lord, insofar as 62 is concerned, they are the primary evidence. Therefore, how the learned judge could reject it on such? May I make one submission?
That I represent the respondent. That so far as the writings are concerned, they are pertaining to one PVA Kada. He is not a party to the proceedings. The first document which they are referring to is pertaining to one PVA Kada, who is not a party to the court. So for the second document is concerned, notebook Alita maintained with the father related to transactions with various persons. Well, the document does not show whose handwriting it is. It does not contain the signature of the party also. Some scribbling Alita have been made by father's petitioner's father. How that is relevant for the purpose of this case? That is the reason why the trial court has rejected on the ground that it is not relevant for the purpose of this case because it doesn't help the case.
Trial court has assigned any reasons?
Well, he has not given any valid reasons. But the fact of the matter is that they are not relevant. If the documents are produced before the court could come to a conclusion that those two documents are irrelevant for the purpose of this case. Even otherwise,
the court can decide whether court can decide the validity of the document at the time of marking a document.
Relevancy, relevance.
Relevancy.
Yes. Whether these documents are relevant for the purpose of this case or not. Because according to them, they are pertaining to one PVA Kada and another document is pertaining to various persons. And it doesn't contain the signature also. It doesn't say that whose handwriting the document is.
What is the definition of section 3 of Evidence Act?
Yes, well, relevancy. Relevancy. If the document is pertaining to relevancy, then the document would be produced. Obviously, my lord, the intention of the court was to say that it was not relevant since the document.
Where is that finding recorded by the trial court?
Of course, my lord, finding is not there. Finding is not there.
It has to go back.
Yes, let it go back.
Yes, Suman.
Please. Lord, all the issue relating to relevancy can be decided by the trial court at the time after marking. No, my lord, whether it is not my father's signature, whether it is my, I will have to prove all that. Mere marking of a document per se is not proof of document.
No, my lord, before marking only, the parties have to be heard. And the finding has to be given as to whether the relevancy or not.
The petitioner. Agreed by the order dated 26/6/2019. Refusing to mark document at serial number 6 and 7 in the memo submitted with IA number 3 has filed this writ petition, order dated so and so, passed in OS number
4871 of 2017.
4781 of 2017 by the 20th Additional City Civil and Session Judge Bengaluru, bracket CCS 32, has filed this writ petition. Brief facts leading age to filing of this writ petition are as and respondent filed a suit for permanent injunction in OS number 721 of 2017 against the petitioner. In respect of such property, claiming to be in possession of such property, having perfected his title by way of adverse possession, to the petitioner filed a suit in OS number 4781 of 2017 against the respondent for ejectment and to pay the sum of rupees 5 lakh towards damages to the petitioner as claimed in the suit, and also to pay damages to the petitioner during pendency of suit in the disposal of suit by holding an inquiry in this regard. First up in the said suit, the respondent filed a written statement as to the trial court claimed the issue. The petitioner was examined as PW1. In the examination sheet, PW1 has produced at this stage, the petitioner has filed an application that is IA number 7 for production of document of IA number 7 for production of additional document. First of the said application came to be allowed by the trial court by the order dated 26/6/2019. First of while allowing the said document, allowed the document and permitted the petitioner to examine as PW1, and the petitioner was examined as PW1 and got marked documents exhibit P158. First of the trial court declined to mark documents at serial number 6 and 7 in the memo submitted an application on the ground that the said documents will not give the sense of evidence as provided under section 3 of Evidence Act. And also the document is not having any proof to say that it is in a counterpart of original documents as stated, as provided under section 62 of Indian Evidence Act. Like the said document, hence this is the petition. Heard the learned senior counsel Sri K. Suman for the petitioner, appearing for Siddharth Suman for the petitioner, and also P. Prakash, learned counsel for the petitioner, submit that the trial court has committed an error in rejecting the said application on the ground that does not sense submit that it does not give a sense of evidence as provided under section 3 of Evidence Act. He further submit that section 3 of the Evidence Act provides that documents means any matter expressed or described upon any substance by means of a letter, figure, or mark, or by more than one of those means intended to be used, or which may be used for the purpose of recording that matter. Moreover, the documents produced by the petitioner submits that the definition of a document and it is a primary evidence. We further submit that the trial court has committed an error in decline to mark the said document. He further submits that the trial court has not assigned any reasons in declining to mark the said document. Hence, on these grounds, he placed to allow the writ petition and direct the trial court to reconsider for marking document at serial number 6 and 7. Hence, per controller and counsel for the respondent fairly concedes that the trial court has not assigned any reason to decline to mark document at serial number 6 and 7 in the memo submitted along with an application. Hence, place to dispose of the writ. Third, and peruse the reports and consider the learned counsel for the party. So the petitioner has filed a suit for permanent injunction against the respondent. So the respondent appeared and filed a written statement denying the evidence made in the petition. The trial court framed the issues. Matter is posted for evidence of the petitioner. The petitioner has filed an application for production of documents. The trial court allowed the application with order dated 26/6/2019 and permitted the petitioner to file an exemption chief in the form of an affidavit. Recording petitioner has filed an affidavit in the form of an exemption chief and got marked document exhibit P1 to P8. The petitioner was intended to mark exhibit serial document number 6 and 7 in the memo. The trial court has declined to mark the said documents on the ground that the said document will not give a sense of evidence as provided under section 3 of Indian Evidence Act. In order to consider the said contention, it is necessary to consider section 3 of Evidence Act, which reads as under document means any matter expressed or described upon substance of means of letters, figures or mark, or by more than one of those means intended to be used or which may be used for the purpose of recording that matter. First of the petitioner has produced a copy of notice made by the father of the petitioner in his own handwriting on a piece of paper pertaining to the transaction which he had with PVAP.V.A father, that is bracket the earlier tenant, and also produced a notebook which was maintained by and written by the father of the petitioner, which contained various notings relating to the transaction which the petitioner's father had with the various persons pertaining to all his properties. So from the perusal of the document, the said document is in the handwriting of the father of the petitioner. As per the definition of document, the document means includes a letter or figure or mark of the trial court without considering the said aspect and without examining the said document has passed the impugned order. From the perusal of the impugned order, the trial court has not assigned any reasons to come to a conclusion to decline to mark exhibit P6, serial number 6 and 7. 7 on this ground alone itself. On this ground, the impugned order is liable. Portion of the impugned order is liable to be set aside in view of the above discussion. The impugned order dated 26/6/2019, refusing to mark documents at serial number 6 and 7 in the memo submitted along with an application to the said extent. Order is set aside. So the repetition is allowed, order dated so and so, to the extent of declining to mark document at serial number 6 and 7 is set aside. Trial court is directed to reconsider the documents for marking after assigning the reasons in accordance with law.
The observations made by this court will not influence the trial court.
Any observation made by this court in the shall be confined only to the disposal of this petition.
My lord, incidentally, my lord said suit for permanent injunction. My lord may have to say suit for ejectment. Dictation ಮಾಡಾಗ್ತಾವು ಮಧ್ಯದಲ್ಲಿ suit for permanent injunction ಅಂತ ಹೇಳಿದ್ರಿ. ರೀಸನಿಂಗ್ ಕೂಡ
ನೀವೇ ಬರ್ದಿರೋದ್ರಲ್ಲಿ ನಿಮ್ಮ ಇದು ನೋಡಿ, ಸಿನಾಪ್ಸಿಸ್ ನೋಡಿ. ಅಲ್ಲ, ಅದು ಅವ್ರು ಹಾಕಿದ ಸೂಟು 721 of 2021 17.
ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ತಾವು ಹೇಳುವಾಗ
Allah, petitioner has filed a suit OS number 7181
Yes,
for
petitioner
rejection.
ಅದು respondent has filed.
Nim synopsis nodi sir.
Allah, first item says 21-122 suit in OS 721 was filed by the respondent.
Ade correct ade helid nanu.
ಅದು petition ಅಂತ ಹೇಳಿದ್ರಿ ತಾವು ಅಷ್ಟೇ.
Respondent.
matter.
Respondent 721 respondent.
Reasons.
4781 petition. 721.
Please.
Serial number 50.
1 second.
Yes. No, serial.
But the other matters.
Just a minute, sir. No, wait. Let's take the petition. Number 50.
Shri D.R. Ravi Shankar. Serial number 50.
Approve the 20th respondent in this matter, my lords.
Okay. Correct. I'm ready to dispose of already. Ready to dispose of the matter, but I want to ask. I got some doubt. No, correct. We have given an X. No, correct. In a second. Sir, right? Fraud is alleged whether it requires evidence of so wanted to get a clarification from the council appearing for the petitioner if you have got a dot. If you have got a question, then I will release the matter from a party. ಅವ್ರ ಹತ್ರ ನಾನೇನೋ ಡೌಟ್ ಕೇಳ್ಬೇಕಂತ ಇದೀನಿ, ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಕಮೆಂಟ್ ಮಾಡ್ಕೊಂತ ಇದ್ದೀನಿ. ಅವ್ರ ಹತ್ರ ಡೌಟ್ ಕೇಳ್ಬೇಕಂತ ಇದೀನಿ. He has submitted, he will undertake that he will not execute an order against us. ಇದು ಯಾವುದು? I will see. ಅಲ್ಲ ನೀವು ಹೇಳಿ ನಿನ್ನೆ ಹೇಳಿ. I'll release the matter from a party.
My lords will not do it, my lords. Lordships, I heard this matter for so much length of time. Again, releasing the parthead, everything has to start up.
Already I prepared a points. ಅಲ್ಲ ನಾನು ಮೊನ್ನೆ ಡಿಕ್ಟೇಷನ್ ಕೊಡಕತ್ರೆ ನೀವೇ ನಡು ಬಂದ್ಬಿಟ್ರಿ. Yes, Ravi Shankar.
My lords, your lordships had already indicated nature of orders to be passed.
As far as stay is concerned, that will be continued till the disposal of application
Sir,
under order 23.
I had undertaken, instead I had suggested, my lords, that I will myself undertake, I'll not restrict it with the, because ultimately it's only the execution which
Okay, take
matters.
down. WP number 6659 of 2017. Petitioner agreed with order dated 31/1/2017. Passed on IA number 8 and 9 under order 23 rule 3, read with section 151 with prayer to recall the compromise decree dated 28/9/2022 in execution petition number 2 of 2012 by the election petition are the petition defined as OS number 4023 of 2000 for the release in respect of property bearing to bar 1 of better city state and same was purchased by the petitioner number 1 and 2 under register sale dated 10/2008 from the parties are referred for their before the council of the plaintiff and the respondent section number 2 to 3 under register sale date from respondent defendant number 2 to 4 in the suit and the said suit having colluded with defendant number 1 and 7 dated 2008 named number 1 in the suit schedule proper under register sale date 2008 First upon 28/9/2012, the plaintiffs and defendant number 1 to 7 in the suit in the said suit filed a conflict petition as decree was drawn. First upon drawing a compromise decree, the defendants in the said suit failed to comply with the terms and conditions of compromise decree. So the petitioners filed an execution petition in number 2 of 2012 along with an application IA number 1 under order 21 rule. The respondent number 17 to 24 who are no way consent to the suit schedule property filed an application as the obstructor to obstruct the execution proceeding. First of the executing court did not pass any order on IA number 1 filed by the petitioner, which is the petition in WP number 2016, seeking for a mandamus directing the executing court to dispose of IA number 1. So this court wide order dated 2/6/2016 disposed of the writ petition directing the executing court to dispose of IA1 within a period of 3 months. For stopping the said execution, the defendant number 2 to 4 filed 2 applications, that is IA number 8 and 9, IA number 8 and 9 for recalling the order, recalling the compromise decree dated 28/9/2008. Recalling the order dated 28/9/2018 and to stay the operation and execution of the compromise decree. The said applications are opposed to the petition. First of the transcript of this application passed the MP dated 30/2017, allowing both the applications filed by the defendant number 2 to 4 and recall the order dated 28/9/2018 and restored the suit to its original number and stayed the operation and execution of the decree, compromise decree, 22 February 2017, agreed by the same as per this petition. Third, the learned senior counsel revision for Sri Palpuram for the petitioner and Sri Ashwat Narayan counsel for respond number 2 and 3. You are appearing for respond number? Narayan for senior counsel for and Sri M. Ramana for responding. Then a senior counsel appearing for the petitioner said the petitioner number 1 and purchased the property number 32 bar 100 of the defendant number 2 to 4 having followed the defendant for 2008 in favor of defendant number 1 in suit schedule property. He further submitted that the denial of the petitioner filed a suit in invoice number 4023 of 2019 for relief of declaration and possession. In the said suit, parties have entered into a compromise and compromise decree was drawn.
Yes, my lords, compromise decree was
Drawn. Most of the defendant did not comply with the terms and conditions of the compromise decree. The petitioner filed an execution petition. First up in the said execution petition, the defendant number 2 to 4 filed an application for following order dated 28 2012. Of the transport without further submitted the transport without holding an inquiry on the application filed under order 23 in order. He submitted on this case order in the under 23 rule for conflict the transport without holding an inquiry on an application filed under order 23 rule 3 to dispose of the receipt carrying the reports in consequence. It is not in dispute that the petition has filed a suit in invoice number 4022 for the release of declaration and possession. The parties have filed a compromise petition. So the trial court has accepted the compromise petition and the compromise decree was done. The respondent stroke defendants in the sense not comply with the terms and conditions of a compromise decree. The petitioner was forced to file an execution petition. In the execution petition, the petitioner has filed an application under order 21 rule 1136. In the meantime, the trial court did not pass any order on the said application. The petitioner approached this court seeking for a mandamus, directing the executing court to dispose of IA1. First of, meanwhile, the defendants defendant number 2 to 4 have filed an application IA number 8 and IA number 9 to recall the order dated 28/9/2012 and also to stay the compromise decree, to stay the operation of the compromise decree. First of the trial court, first of the defendant number 2 to 4 made a serious allegation against the petitioner, stating that the petitioner has played a fraud on the defendant number 2 to 4 and obtained a signature on the compromise petition, and thereafter it was presented before the court. And it is also contended that the defendant number 2 to 4 were not being identified by the council, appearing not identified by the council, but not identified by the advocate, First up, when a serious allegation was made, the trial court ought to have held an inquiry on the application filed under Order 23 Rule 3. First of the trial court, without holding an inquiry under Order 23 Rule on application filed under Order 23 Rule 3, has proceeded to pass an impugned order. Hence, on this ground alone itself, the impugned order passed on an application under Order 23 Rule 3 requires to be set aside. In view of the above discussion, the repetition is allowed in part. The order dated 31/1/2017, which is IA number 8 and which is IA number 9.
IA number 8 is under Order 23 Rule 3.
23?
The orders. That is IA number 8, Milords. That is the application on the basis of which, Milords, the
impugned order dated 31/1/2017 passed on IA number 8 is set aside. Trial court is directed to consider to hold an inquiry on IA number 8 and then pass appropriate order in accordance with law within a period of 6 months from the date of receipt of copy of this order.
may request for 3 months, Milords, because
the present situation, it is 6 months is also
very well. I leave it at.
As far as IA number 9 is concerned, I'll not disturb it.
Milords, IA number 9 is concerned. I stated, Milords, that IA number 9, he has suspended the operation of the compromise decree. Compromise decree is in several parts. The people who have challenged is only few people, but anyway, compromise decree requires to be executed. I'm giving an undertaking. I'll not precipitate the execution till the disposal of the application.
The next senior counsel, we are referring to the petition. Undertake that the petitioner will not execute the compromise decree till the disposal of IA number 8. His submission is placed on record. Accordingly, submission is placed.
I have a small submission to make, my lords, in this matter. I have a submission, my lords, if I'm not interrupting. This matter, my lords, I have 25% share in the property, which is under surface proceedings, my lords. In the DRT, Hinduja Leland Finance has initial surface proceedings, around 25% of my share in the property, my lords. It is the SA is pending before the DRT, my lords. That is the only submission I want to make. Because if he says that because I am not the party in the compromise, he wants to take away my share. My share is already in the surface proceedings also.
Go and file
That's why that the interim ought to be for the entire property, my lord.
No, sir.
Not for only
whatever the relief which has been sought in IA number 9, I'm telling. As far as
they say that it is only for those people who entered the compromise, that they will not execute. For others, they want to execute. But my share is the 25% is already in the DRT, my lords. Honorable DRT, it is there.
Yes, sir.
Therefore, it should be extended to all, my lords. That's all.
So, which are the properties in the compromise that will be stayed? This 45875/2017 does not survive in your undertaking given by the petitioner.
Your lordships may say that the writ petition would not survive because that order, my lords, now is dependent on the outcome of the inquiry.
Yes, yes.
This may make this
order has to be the disposal of writ petition number 6659 of 2017, and also in view of the undertaking given by the learned senior counsel for the petitioner. This repetition does not survive for consideration.
I just wanted to make this mention that order has to be set aside, but I'll have to be permitted to reinstate this matter after the disposal of the order, IA number 8, because there is an adverse order against me in this matter.
Correct. You are given an undertaking that will not execute.
I will not.
Disposal of IA number 8. Once if IA number 8 is disposed of, you can execute it.
One observation at your lordship's hand, because they should not come back and say adjudicator applies at all stages of proceedings.
You have the disposal of petition number 6659 of 2017, as the petitioner has undertaken not to execute a compromise decree passed in OS number 4023 of 2009. Nothing survives for consideration in this repetition. This repetition is disposed of. However, liberty is reserved to the petitioner to execute the compromise. The result on the outcome of IA number 8.
Please, great. Yes, great.
May I please, Lordships?
Correct,
Please.
but now when there is a doubt, we should get it clarified. Without the clarification, we cannot dispose of the.
May I please, Lordships? May I make a submission?
Yes, sir.
Item number 47.
I appear for the petitioner in that matter.
Next week.
Serial number 50.1.
47. 47.
My lord, I appear for the petitioner. I mean, there's some urgency. They're undertaken to pay a sum of amount to the son, who is the petitioner.
No, it has become infructuous.
It is not, my lord. If your lordship,
If they want to argue, my lord, Lordship, kindly have it next week. I'll argue the matter.
hasn't been complied with, my lord, thus far. That's my instructions.
Ah.
So if they're seeking adjournment, if a date may be fixed next week.
Now serial number karita dar sir.
Passed over matter, serial number 9, Shri D.R. Sundaresha.
My lord, for the respondent, my lord.
Yes, sir.
My lord, what I was submitting, my lord, is that I'll take 2 seconds, my lord. We have agreed to give them 1 acre of their land which they are claiming, and we were not able to physically reach Mr. Sundaresh. Now the client has given me the emails, so they just have to identify that 1 acre of land. With that, the entire suit goes, my lord. I request my lord to kindly take it a day or 2 later, because my difficulty is Mr. Sundaresh is not coming to the court. He's only on video hearing. That's the only difficulty.
I request of Learned Council for respond number 3. Let the appeal be listed in the 2nd week of March.
Obliged.
Serial number 32.
Council for the petition. Let the petition be listed in the 2nd week of March. Appeal. We are withdrawn admission made in the proceedings. This is not permissible. ನೋಡ್ರಿ ಪಾಟೀಲ್ ನಾನು ನೋಡ್ಕೊಂಡ್ ಬಂದಿರ್ತಾನೆ ಬೆಲೆ ಏನ್ ಇದ್ದಿದ್ದು ಅದು ವಿಡ್ರಾ ಮಾಡ್ಬೇಕಂತ ಇದ್ದಾರೆ ಕಮ್ಸ್ ಟು ವಿಡ್ರಾಲ್ ಆಫ್ ಅಡ್ಮಿಷನ್ the petition listed in the 3rd week of March
I appear for the petitioner.
In this case, kindly see the impugned orders at Annexure F.
Lord, I may be permitted to submit if my learned senior counsel permits me.
I'm only requesting if this
This is a petition challenging orders made in execution proceedings seeking enforcement of a compromise decree between a father and a son. The son had filed a partition decree wherein they were compromised that the father, for his continued enjoyment and occupation of the scheduled property, would pay maintenance of 15,000. May your lordship kindly take page number 21, my lords. The compromise decree is there. That relevant part would be in page number 23. Clause 4B. The defendant shall pay a sum of rupees 15,000 per month as maintenance to the minor plaintiff by depositing the same on or before 4th of every month into the bank account of the minor. There shall be an escalation of 10% on the said sum every year. My lords, this compromise petition was entered in the year 19/3/2014. Thereafter, no payment was effected, which compelled me to file these execution proceedings. I duly filed a memo of calculation before the trial court.
Next week.
I request a date may be fixed.
Next week.
Serial number 48.
Petition be listed in the 1st week of May.
48. Are we
I
just
appear for the petitioner. But in all these cases, an interim order may kindly be, interim order is there. It may be extended if the court has no time. Otherwise, I am ready.
If one writ petition is allowed, you have to allow all the writ petitions. Now the question is framing of additional the preliminary issue.
Preliminary.
Yes.
Well, it cannot be under Order 14. Now, as amended, it does not touch the jurisdiction of the court, or it is not barred by limitation.
No, correct. They say that suit is not maintainable for non.
No, suit is
Without seeking for the relief of declaration. Proviso to section 34 of Society Relief Act.
No, my lord. I appear for the petitioner. Well, this is a suit for possession based on title. Well, such a suit is maintainable, and there are 3 sets of dependents. Well, in 4 cases, dependents have remained ex parte.
Your objection.
Pardon.
Let the appeal be listed, let the petitions be listed in the 3rd week. Interim order granted earlier is extended till next week of April.
In all the cases.
Second week. First week.
Serial number 51. PD Subramania for final hearing.
I appear for the respondent. Court officer. Court officer.
Sir, one nimsha bartar.
Sir, final hearing is adjourned, sir.
Agenda 51.
Yes.